255593 FH. You are charged with unlawful imprisonment punishable by 15 years, assault with intent to do great bodily harm less than murder, or by strangulation punishable by 10 years. Count 3, assault with intent to do great bodily harm less than murder, or by strangulation punishable by 10 years. Count 4, domestic violence. And there's a third offense notice, so it's enhanced to 5 years. You are charged with count 1, home invasion, 3rd degree, punishable by 5 years in docket 255596 FH. In docket 255332 FH, you are charged with count 1, domestic violence. Again, 5-year felony because it's the 3rd offense. Count 2, assault with a dangerous weapon, also known as felonious assault, punishable by 4 years. And count 3, weapons felony firearms, 2 years consecutively within preceding any term of incarceration. And finally, docket 254783 FH, possession of a controlled substance known as cocaine, punishable by 4 years. You were on bond conditions. And now I have allegation, or no, I don't have any allegations, but I understand the people have some information in regard to your counsel's request for bond. Ms. Schroeder, have you seen the people's response and lengthy attachment?
Yes, Your Honor, I have seen the response. I have reviewed the attached documents. I've also shared a copy prior to this hearing to my client of the response, and he is aware of the people's position.
All right, and your motion.
Thank you, Your Honor. I believe that the court has reviewed the documents, the motion that we put forward. I realize what the allegations are from the people. I didn't receive those additional information until about 4 o'clock on Monday afternoon, well after I'd already filed this motion. I realize that these are serious allegations. Mr. Howell understands that as well, but he has been held in custody for quite some time, no phone privileges, anything, and he has some medical conditions that are outlined in my motion. We would ask the court to consider any bond reduction still. Thank you.
All right. Counsel, response?
He has been held in custody without his phone privileges because he did all of this back in district court. We went through this song and dance with Mr. Howell back then. He tried shouting at the court that that wasn't his face in the video visits that clearly showed his face. He tried saying that he had no idea about any of this.
Your Honor.
The court.
If you speak up, here's what happens.
My
Let me
apologies.
just instruct you for a moment.
Yeah, ma'am.
If you speak up out of turn, everybody in my court gets to talk. Been widely known for the 22 or 23 years I've been on the bench. I take my time, everybody gets to talk. Probably more people than should be able to talk or that any other judge will allow. But I also hold people in contempt.
Yes,
If you
ma'am.
decide to interrupt and be disrespectful to your counsel, this court, or the prosecutor, it's called contempt.
Yes, ma'am.
Contempt carries with it 93 days and or $7,500. You don't have the $7,500, but you got the 93 days. And that is separate and apart from anything you may serve on these files.
Yes, Your Honor.
And I will not continue this hearing until that 93rd day. So I suggest you don't say anything until I address you. Are we clear?
Yes, Your Honor.
Thank you. Sorry for the interruption, counsel.
That's okay. So in response for preparing for this, I, on Monday afternoon, ran the victim's number through again, looked at the user account again. And to be clear, I only counted in my response the amount of new contacts that have been made since the district court hearing on August 28th. And then I put in my response, he has called the victim's phone number since that date 1,181 times. That's not in addition to the pages of e-messages and the video visits, again, all from other inmate accounts like he was doing back then. Still, in several video visits, showing his face again, despite it being on the other inmate accounts. All of that aside, he had the two original files, including one which, with this same victim, absconded for, I think, 3 years or close to that, and then was picked up on 2 new felony files with this victim. So the defendant absolutely poses a flight risk because he has literally taken flight before for half of these charges, or half of these cases. On top of that, he seems to be completely unwilling to actually follow the orders of the court. The reason that there weren't prior PA-53s and witness there weren't prior PA-53 violation hearings and witness interference charges at district court was because the APAs who handled those hearings while I was in trial agreed to waive them up here, to get the cases up here where they can hopefully be resolved. So he knew we were watching, he knew there were potential consequences, and he kept doing it. So, Your Honor, I'm asking that the court not just reject the bond motion, I'm asking that you remand his bond and set this for PA-53 hearings in the 3 cases that involve the assaults, or sorry, the victim, Ashley. That being file 255593FH, 255596FH, and 25533-2FH. I'm going to be asking that this court, if it does set the bond violation hearings, that it set them in 2026, because the offer, I already told a defense attorney this before we went on the record today, but I will put it on the record again. Because of these contacts, frankly, the offer that I put on the table, I probably shouldn't keep on the table, but I'm going to with a ticking clock on it.
What is the offer?
The offer is for the defendant to plead guilty to count 1, unlawful imprisonment in file 25-5593FH. Plead guilty to count 2, felonious assault, and count 3, felony firearm in file 25-5332FH. The people agreed to dismiss all remaining counts. People agreed to dismiss files 25-5596FH and file 25-47F3 or 4783FH. With any restitution to be included. And the people agreed not to pursue witness interference charges for contacts made prior to today's date, that being December 17th, 2025. That offer is going to expire January 1st, 2026, the start of the new year. If I do not receive a message from the defense counsel saying her client wishes to accept this offer, that offer is going to be gone, and I'm going to be in contact with the detectives who have additional cases for the witness interference for each of those 3 files. So that is why there is a ticking clock in there. That's why I ask any bond violation hearings to be set for after 2026 in the hopes that this can still be resolved before that time.
And as to Ms. Beauchamp, is she on board and needs protection and she'll show up at trial?
Your Honor, given the amount that this defendant has worked to make sure she does not appear, I doubt it, but that's why forfeiture by wrongdoing exists. What is interesting to me is toward the end of the messages, she has stopped responding to him, has blocked the jail number, and he is very angry with her about the fact that she's not talking to him anymore, while poor him is sitting locked up. Which also shows me this isn't about willingness, because it's not about what she wants. It is him barraging her with messages over and over and over to get what he wants. I have no doubt that given the unbelievable extent to which he's been doing this, that he's likely to be successful. But that's why the law accounts for those efforts to ensure that he does not benefit from that. Like I said, I have no doubt that it's been successful. He is up there in the running for one of my most prolific violators. I think I only have one guy bigger than him. That was, I think, Jason Phillips with 1,400. He's close, and we're not even at the stage that Mr. Phillips was.
Thank you. Response?
Thank you, Your Honor. I hear the prosecutor's position. However, Mr. Howell does maintain his innocence.
So let me just stop you there. And I want to be very clear to you, sir, and your attorney knows this. You are innocent until proven guilty beyond a reasonable doubt. The considerations for bond are different. Safety of the public, safety of the victim, whether you reoffend, will you reappear? There's different considerations along with your history and the actions. So I have different considerations and well understand you're innocent until proven guilty beyond a reasonable doubt. But you need to understand there is a difference because you need to behave during this time. And so that's what we're talking about is, did you follow the court's orders? I'm sorry for the interruption, counsel. Now you may proceed.
Well, let me finish. What I will say is Ms. Beauchamp, as the prosecutor indicated, has not ever appeared for any of our court dates, whether at the district court or, well, at the district court anyway. I cannot speak entirely as to here, as I'm usually otherwise occupied with regard to Mr. Howell's matters in this court. I have and the prosecutors received paperwork regarding recantations and other matters, and as to her. So at this point, that is where that is out, at least from the defense's perspective. Thank you.
Sir, now what would you like me to know?
Actually, yes, me and her did make several contacts.
Stop.
Excuse me.
Sir, you've admitted to violating by that statement. You've admitted to violating.
We have a baby that is.
I don't care if you have quadruplets. No contact means no contact. If
Yeah,
she's the custodial parent of
Yeah,
that, you're
yeah,
not allowed to contact her.
Yeah, ma'am. I never once caused no anger of any kind. She did this willingly. She sent in recantations.
Sir, you are making statements against your interest. Anything you say or write can be used against you. And the prosecutor is here listening. There is a court reporter, and your statements are against your interest. And right now, I don't need a hearing. I can hold you in contempt.
And he lied on me and said that I wasn't in a, never mind. Cause y'all keep, whatever I say, you saying that like I can't talk or something. You just
You
ask
can
me.
talk, sir, but I'm telling you, I'm trying to protect your rights. Your attorney is there jumping up and down saying, don't talk, don't talk. Not because she doesn't want you to talk, but because she doesn't want you to admit guilt, which is what you're doing to this court.
Judge, Your Honor, you're yelling at me. I'm innocent until proven guilty. Y'all looking at me as if I'm guilty already. Where's the justice in this courtroom? Is there any justice?
Sir,
Is there any justice, or I'm looked at as a criminal? I'm not a criminal.
as I said to you, very calmly, but yes, did you upset me by violating what your attorney and I have clearly said? You should not make statements against your own interest. I'm trying to stop you from harming your case.
Yes, ma'am, I understand.
You are innocent until proven guilty beyond a reasonable doubt on all 4 files.
Then why am I being yelled at?
Because,
I'm being yelled at by
sir,
you, in him, in her.
I'll tell you why. Because there were bond conditions and you were a free man.
I was never a free man.
Well, okay. You were a man who is on bond conditions regardless.
And I became ill with a illness disease called TTP. That's why this has been going on. Since 2022, I have an illness or disease that has no cure for it. And I was in a hospital for over a year.
Okay, so I'm sorry about that. But does that illness cause you to make 1,000+ phone calls to the protected person?
Yes, actually it does. It plays tricks on my mind, actually. With suffering from autism and medication that I take from the mental institution, yes, it does. So
Well,
mentally, yes, ma'am. Unstable, shall I say, pardon my word.
Well, we can send you over to forensics. I think if that's what you want to do, counsel, maybe you ought to talk to the prosecutor and we have him evaluated at forensics based on those statements. If he's doing acts that are uncontrollable because of mental illness.
I take medication because I hear voices and everything else.
Okay,
So schizophrenia, PTSD, and autism that I suffer from.
okay,
Those are all the medications that I take.
To be very clear, Judge, the people don't believe a forensic or competency evaluation is needed, but it's
The
also
people
not
don't believe what?
that competency evaluation is needed. People are pretty sure it's employed, but it's also not our place to stand in the way of that. So
Okay.
that is not any part of our decision.
Ms. Schroeder, do you believe he needs to go to forensics based on what you've heard today?
Based on what I've heard today, based on the statements he's made to the court, I don't believe I have a choice, Your Honor. I think it sounds like he does need to go at this point.
Counsel, would you like to step in here?
No, thank you.
Thank you.
I'm telling you, all right, I need help.
Well,
In light of that, Your Honor, all I will say in terms of nuts and bolts with the offer I made with that deadline, assuming he's sent to forensics and when he's found competent, the deadline will be for 3 weeks after that finding.
Understood.
Oh, and the people will be requesting a transcript of today's proceedings with the statements he made.
granted. We have the paperwork. I can send you over to forensics, sir.
Yeah, ma'am.
Great, done. We're gonna send you over to forensics. You understand the plea offer. It'll be restated again. We'll have a final pretrial. If you're not competent, then you can't make any decisions. You understand, hopefully, that there is no contact. She does not exist in your world. I don't care if you have 100 children with her. You're not allowed to have contact with her, and she is the custodial parent of that child or children. So there's no contact, no contact, no contact. You understand that either directly or through third parties, no Hallmark cards, Christmas presents, messages through carrier pigeon or smoke signal. You understand no contact, or would you like me to explain it a different way?
No, I understand, Your Honor.
Because the people certainly, from what I have heard today, are, and it looks like they will pursue witness interference, which could very well explain why she's not here, and reasonable persons would feel intimidated, harassed, and demeaned by over 1,100 phone calls. So I don't know what's gone on here, but you just want a trip to forensics.
Okay, Your Honor.
I'll sign the paperwork today.
Sorry, Your Honor. I was gonna ask, does the court have paperwork that I can fill out, or do I can take care of that and I will make sure it gets filed?
Your
We
Honor,
do.
the people do have a concern that this is an attempt to evade contempt
Understood.
hearings. So I'd ask that we still put contempt hearings on the books for those 3. And if we need to, we can adjourn them down the road.
Well, yes,
I just want to
however,
make sure it doesn't get lost.
it's not going to get lost, because if he's found competent about today, I've already heard enough to find him in contempt. I don't know why I need to have a hearing.
I didn't want to be presumptuous, but I certainly agree.
So we'll see how it all falls out. Everything's preserved. Ms. Schroeder, please prepare the paperwork and I will sign it this morning.
Very good, Your Honor.
We stand in recess, and this will, once we have a result, sir, we will have to arraign you within, or make a finding within 5 days of your return, and then we will set that also for our final pretrial. Would you like competency as well as, do we need to do both? I don't know what happened at the time of these offenses.
I mean, based on what he said today, if we're going for one, we should probably send for the other.
Agreed. Let's do both.
Yes.
Thank you.
Thank you, Your Honor.
That's all for the record.
Thank you, Your Honor.
Nancy, yeah, when you, both sides need a copy of that transcript.
Okay.
I think we probably should send one to forensics, but I need one in the file when you do it. which you usually do anyway, but we'll need it in the file.
You can do it for getting a copy of that transcript as well.
I just told Nancy to give forensics, you, counsel, and me a copy. So everybody knows what we're dealing with, and we remember this, not that we'll likely forget it, but with so many cases, and actually both of his attorneys, she could have.
Yeah, thank you.
All right, thank you.
And then
All right, who else is ready?
Since Debbie's come back already on Brown.
Is it brown or is it gold?
Is that with Mr. Freeman, because he's just with.
Yeah, Freeman just went, they just grabbed, just grabbed, just came in and
That's
grabbed.
Garza. Garza.
And what are we doing on this?
This is gonna be a plea, Your Honor.
What about Brown?
That was Elizabeth, so Mr. Freeman just walked out, that's gonna be, he's asking the court to respond.
Not, we're addressing it's a final criminal pretrial conference. That's what we're addressing. Then we might be able to address that. You want to let him know that? I think there's no bond issue until we deal with the final pretrial. That's what it's set for. Granted. All right, this is docket 25845 FH and 25842 FH, People of the State of Michigan versus Lorenzo Freddy Garza. Counsel, your appearance for the record.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Good morning, Your Honor. Assistant Public Defender John Lee appearing on behalf of Lorenzo Freddy Garcia. I'm sorry, Garza.
Good morning, Your Honor. Jacob Sars, the fourth Assistant Public Defender, here as co-counsel and acting as senior counsel for Mr. Garza. Thank you.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to take medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness? Have you had enough time to talk with your attorneys?
Yes, Your Honor.
All right. And sir, when you're not in lockup, do you live on South Rosemary?
Yes, Your
And who lives there with you?
Honor. Grandma and my mom.
And are you generally gainfully employed?
No, Your Honor.
Have you ever held a job?
Yes, Your Honor.
Or what do you do?
I work my warehouse, Wendy's, work the foil, work a lot.
So you have skills.
Yeah.
Did you graduate high school?
No, Your Honor.
How far did you make it?
Freshman year.
Ninth grade? Did you finish ninth grade? Are you a US citizen?
Yes,
All right, and can you read and write?
yes,
Okay, very good. So you've gone through with both counsel, the documentation and signed it.
yes, Your Honor.
Okay, very good. And you were able to ask them any questions you might have wanted to?
Yes, Your Honor.
All right. On behalf of the people, and what is the plea agreement in each file?
Thank you, Your Honor. The agreement on file 25-842 FH is for the defendant to plead guilty to an added count 5 of home invasion 3rd degree. And on 25-845 FH, for the defendant to plead guilty to an added count 5 of stalking. The balance of both files to be dismissed upon successful plea acceptance.
Full, fair, accurate, and complete?
Yes, Your Honor.
Yes, Your Honor.
Sir, full, fair, accurate, and complete? But she just read the, as to the agreement, you'll be pleading the
Yes, Your
one,
Honor.
okay. And it would be true that any contraband, if any, would be forfeited, as well as any restitution on all counts, including the dismissed counts, would be paid. Is that correct?
Yes, Your Honor.
Agreed?
Yes, Your Honor.
Agreed, sir? Do you understand that? Okay. And was the victim consulted?
Yes, Your Honor, our office has reached out to the victim.
I'm sorry, what?
Our office has reached out to the victim.
All right. And as to the stalking, sir, you understand that there is part of the statute, no less than 5 years probation.
Yes, Your Honor.
Okay, so you have to serve the full time of probation.
Yes, Your Honor.
Okay. And counsel's waiving on docket 25845 FH, reading count 1 was dismissed at preliminary exam, but reading count. So you added,
It'll be a misdemeanor stalking, Your Honor.
oh, I see. Okay, so misdemeanor stalking. So you are waiving reading counts 2, 3, and 4 on docket 25845 FH, and that stalking, I believe that would be 2 years, not 5 years of
Actually, 1 year, Your Honor, and up to 5 years of probation.
on the misdemeanor too.
Yes.
Okay, okay, I don't have it in front of me, so, all right, and then you're also waiving reading on docket 25842 FH, count 1, 2, 3, and 4, and habitual second is also being waived.
Yes, Your Honor.
We waive a reading.
Yes, Your Honor. Thank you.
Thank you. As to the added count 2 on what will be the amended information in each file, I'm sorry, count 5 on what will be the amended information. On each, you may proceed.
Thank you, Your Honor. And the people of the state of Michigan versus Lorenzo Freddy Garza, case number 25-842FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about April 12th of 2024, at 722 Kaywood in the city of Lansing, Ingham County, the defendant did in the added count 5, home invasion 3rd degree, did break and enter or did enter without permission a dwelling located at 722 Kaywood Street with the intent to commit domestic violence, a misdemeanor therein, contrary to NCL 750.11A4, this being a misdemeanor punishable by up to, this being a felony punishable by up to 5 years and or $2,000 in fines. And in the people of the state of Michigan versus Lorenzo Freddy Garza, case number 25-845FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about April 10th of 2024 through and including May 28th of 2024 at 722 Kaywood Street in the city of Lansing, Ingham County, the defendant did in the added count 5, stalking, did engage in a willful course of conduct involving repeated or continuous harassment of Alitha Herrera, ELITHA HERRERA, the conduct being such that would cause a reasonable person to feel frightened, harassed, intimidated, molested, terrorized, and threatened. And said conduct did actually cause Alitha Herrera to feel frightened, harassed, intimidated, molested, terrorized, and threatened, contrary to NCL 750.411H, this being a misdemeanor punishable by up to 1 year and or $1,000 in fines with probation for up to a term of 5 years. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest, this being done against the peace and dignity of the state of Michigan.
Thank you, sir. Did you understand what was just read?
Yes, Your Honor.
So you understand on docket 25-842FH, count 5, home invasion, 3rd degree is a felony punishable by 5 years and or $2,000 in fines plus restitution for any personal or property damage.
Yes, Your Honor.
And you would also be responsible to pay restitution on the dismissed counts.
Yes, Your Honor.
And if you disagree with the amount of restitution, you can ask for a restitution hearing and the court will decide at hearing whether that amount is correct. It can go up, it also can go down. Do you understand all that?
Yes, Your Honor.
And then you understand count 5, misdemeanor stalking is punishable by up to 1 year with mandatory 5 years probation and $1,000 in fines plus costs.
Yes, Your Honor.
Okay. And it looks to me like your DNA is probably on file, is that correct? Because you have a habitual, did they ever take your DNA? Do you know if it's on file? Okay, if it's not, then did they swab you at the time of
No.
either arrest? Okay, so I'm gonna have to sign a DNA order and they'll come and swab you, okay? You understand? Thank you. Sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, your attorneys were able to answer those.
Yes, Your Honor.
Do you have any questions about your rights at this court?
Your Honor.
Sir, as to docket 25-842FH, count 5, home invasion, 3rd degree, how do you plead?
Guilty.
As to docket 25-845FH, count 5, stalking, the misdemeanor stalking, how do you plead?
Guilty.
Sir, do you understand that by pleading, you're giving up your automatic right of appeal? If you had a bench trial or a jury trial and you were unhappy for any reason, the Court of Appeals must take a look at your unhappiness, but now it becomes their decision. And if they disagree with the importance of your issues, they do not have to take up your case. If they agree, they will take up your case. Do you understand that?
Yes.
If anyone forced, threatened, coerced you, promised you something we haven't made a record of, you need to tell me that now, because if you come back later and say, Judge, I shouldn't have pled, then I don't have to withdraw your plea. Do you understand that?
Yes, Your Honor.
Have you pled of your own free will?
Yes, Your Honor.
And you did that after talking with your attorneys?
Yes, Your Honor.
And you've been satisfied with the representation by your attorneys on both files?
Yes, Your Honor.
And so you understand that by pleading, you're giving up the presumption of innocence, the ability to cross-examine any witnesses or evidence, the ability to hold people to the burden of finding you beyond a reasonable doubt. If not, then the case or cases would have to be dismissed. Do you understand all of that?
Yes, Your Honor.
And it appears to me there's no sentence agreement. Is that correct, counsel?
That's correct, Your Honor.
Correct, Your Honor.
All right, thank you. So we're looking at docket 25842 FH. And that is the stalking count 5. Did this occur on or about April 12th, 2024 in the city of Lansing County, Bingham State of Michigan?
Yes, Your Honor.
And that was at a specific location known as 722 Caldwell Street?
Yes, Your Honor.
And did you come in contact with Aletha Herrera, Herrera?
Yes, Your Honor.
And did you contact her a number of different ways?
Yes, Your Honor.
How did you contact her?
That's phone.
You guessed the phone? Well, how do you guess it? You either used the phone or you didn't.
Well, I did. Yes, sir.
And did you contact her by phone and other means to such a degree that it would put a person in fear?
Yeah, you do.
And did you, during those conversations or phone calls or contact, make threats or act in a harassing way? Like she would interpret that?
Yes, Your Honor.
On behalf of the people, any additional questions? Obviously, I don't have a police report and don't know the
No, I think Your Honor covered it.
council.
No, Your Honor.
Thank you, Your Honor. That should be satisfactory.
Thank you. Moving on to the home invasion third degree docket 25842 FH. Did this actually, I think on the last one I said it was the 12th, but it was actually April 10th that it was the misdemeanor stalking, not the 10th. Would you agree with that, sir?
Yes, Your Honor.
All right, but moving on then to the 25842 FH, did this event occur on or about April 12th, 2024?
Yes, Your Honor.
In the city of Lansing County, Bingham State of Michigan,
Yes, Your Honor.
at a specific location known as 722 Caldwood, CAWOOD?
Yep.
And did you enter that dwelling without permission?
Yes, yeah. I mean,
I can't-
I lived at that address, but I guess,
Okay, you lived at the address, but you had no permission at that time to go, is that correct?
yes, Your Honor.
Had you been living somewhere else?
Yes, Your Honor.
Sir, you look to me like you're just saying what you're supposed to be saying and it's not truthful. Tell me what happened.
Well, none of this, I did none of this, you know, I mean,
We don't have to plead. I got plenty of
I
time.
know, but I don't have time to sit in jail, wait, because I have a kid on the way, and I gotta be a man at the end of the day.
Is this kid with Ms. Herrera?
No, it's not.
Well, let me just tell you something.
I don't want nothing to do with Miss Herrera ever
Okay.
again.
Okay. You might have a kid on the way, but given what I have here, and I don't know much about your case. When I'm enlightened, a couple things could happen. You might have contact with your child, you might not have contact with your child. I have to figure out if you're a danger to a child who can't protect themselves. So just because you are pleading does not mean that you have the green light to have contact with a baby. So if you're pleading to get this over with, and what you're telling me is not truthful, because you're doing it just to get it over with, it doesn't solve all your problems. So sir, what happened here? If this didn't happen, let's go to trial. I got plenty of time on my docket.
Well, it's gonna take like 6 months. I'm not trying to say.
Well, maybe you can get out, maybe not. I don't know. You can get out on bond. I don't know.
I was going to do better, that's all.
I'm sorry, can you say it again? I didn't hear you.
What?
He said, I just want to do better. That's all I want to do.
do.
Counsel, are you satisfied that he should be pleading to these counts? I haven't seen the evidence. You know I don't get police reports, but when I'm looking at him, he's like a puppet saying what he thinks I want to hear, not what I feel is truthful. So I'm concerned.
I believe that his comments on the record today raise valid concerns, Your Honor. And it's not that I don't think that the plea deal is a good deal.
It's a good deal.
Right, I just think that if he's not willing to step up to the microphone and say, yes, I did this, or I am actually guilty, if he doesn't truly feel that way, and I've counseled him that too, I've told him, we're more than happy to go to trial.
And it's the best job I got, so I'm not consider it. All right. Pointless.
It's not pointless, sir. Juries find people not guilty all the time. If the evidence doesn't rise to beyond a reasonable doubt, you deserve not guilty. If Ms. Herrera doesn't show up, you might not even go to trial. I do not know.
Well, I've been waiting since January. I was in jail for what, 4 or 5 months. I went to the 4 or 5 different courts, and she still hasn't showed up. She had not seek any medical attention. There's
Counsel, you continue your whatever negotiations. I'm not, it sounds like he's doing this just because he's got a baby on the way. And as you know, me, and I think countless judges are not going to allow these files, once he pleads and makes this record, for him to be alone with the baby. So I don't know what's going on here, but this is not coming in front of me right now. Let's set her for trial, and then whatever happens, if she doesn't show up, a whole different ballgame. Let's get to it and bring her in and see what's going on. I'm dissatisfied with this.
Understood, Your Honor. I have a series of,
Sir, your rights are important. If you want to throw them away, that's your prerogative, but you got 2 fine lawyers here. And what I'm witnessing here is a reluctant plea that will affect the rest of your life, could affect where you're able to take that baby, when you're able to see that baby, and a whole lot of other things in your life. Not willing to take it. I need to be convinced that you're guilty, and I'm not. So, counsel, what's going on here? Is there a bond motion?
Your Honor, Mr. Garza was remanded because he had allegedly absconded. And
Well, he didn't allegedly abscond, as I recall, but okay.
correct, he admitted that he had failed to appear for his court date, Your Honor, and I will be seeking a bond motion for him in February. And if Your Honor is inclined to order a trial date for him, that is fine. I do have quite a busy schedule, but I'm sure we can get him in, and we'll get this case tried. And Mr. Lee is my co-counsel here, so that will help cover some of that. Certainly, Mr. Garza, it is your choice. And if you have any second thoughts about how you want to proceed with this, it's important that we get it cleared up now. So, Mr. Garza, you have an opportunity today, right now, at this moment, if you'd like to talk to Mr. Lee or I, and reconsider your options at this point. Otherwise, we are free to set this for trial.
No, just set the trial.
Okay.
On behalf of the people in regard to bond,
Given Mr. Garza's past absconding plus the stalking charges, we would oppose any reduction of bond at this time. We would ask for a formal motion in order to brief this more clearly.
remind me why you didn't show up last time.
I was issued a warrant for not reporting when I did report to the pre-trial lady. And but I should have showed up at the time.
How long have you been in lockup this last time?
This time right now,
Yeah,
30, almost 20 days.
what'd you learn, sir? What'd you learn about not showing up?
I go back here.
Are there any other pending files I need to be aware of
No, Your Honor.
on behalf of the people?
There are not, Your Honor. We have not. No, there are not. I would say that it does appear, and I'm trying to pull up the exact notes now, Your Honor, but it does appear that there was also a failure to appear in the district court on the initial case as well. Or some sort of bond violation.
And remind me who you're living with?
My grandparents.
Are you allowed to live there still?
Yes, Your Honor.
Council, you have your schedule for next year? You have your schedule for next year?
Yes, Your Honor.
Great. We're gonna have February 11th is the next court date. At 11 a.m.
Your Honor, I am going to be gone on vacation from
Oh,
February 6th through February 10th.
Okay. well,
However, I do have co-counsel, Mr. Lee. So this
I
could
can make it
be,
the 18th.
well, I was just going to say, Your Honor, this could be a good teaching opportunity for Mr. Lee to get some very valuable experience with very serious charges with me supervising. And I will work through my vacation to potentially be prepped in case we need to proceed.
Everybody needs their vacation. It's gonna be February 18th at 11. I know Mr. Lee to do a good job, so I'm not worried about that, but February 11th, I think it's important that you're both working the case and counts and the client feel that both of you are there, so.
February 18th, Your Honor?
At 11 a.m.
Okay. Thank you, Your Honor.
gonna give you some bond conditions here, and if you decide to not follow them, will entertain another release, and law enforcement knows you. They will find you. You can shave your beard, you can dye your hair, you can gain weight, lose weight, do whatever you want. They are very good at finding people. So show up each and every time, because I won't be entertained again. I'm giving you a $50,000 PR bond. You will report to pretrial services weekly and as directed by pretrial services, so whether it's phone, in person, whatever it is. You will be placed on a jail GPS tether, and there's an indigency grant, which I am fairly certain you will qualify for. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of that, you will show a prescription from a licensed medical physician to pretrial services within 24 hours. You'll take any psychotropic medication, if any, as prescribed, and follow all doctor's recommendations. You will PBT and or drug test as requested by pretrial services, law enforcement, any court officer, or your grandparents. You shall not own, have in your possession, or under your control any weapon, gun, ammunition, or imitation of a weapon. You'll not be in the presence of anyone who has those items. You will not be in the presence of any known gang members. You'll not wear any gang colors, insignia, or gang tattoos. You will maintain your residence with your grandparents. And you will be part, not you may be part, you will be part of a work seek program and become and remain gainfully employed. You will appear for all hearings and proceedings. The next one is February 18th at 11 a.m. You will have no contact with Olitha Herrera, and you will not be within 2,000 feet of her school, work, or residence. You will sign up for a GED class and attend.
I have a question. Where do I do that?
Well, pretrial services will set you up, and actually, right now, Lansing Community College has a really good program, so you can get high school and college, maybe even trade school. There's things online, Lansing Community College, there's a lot of places, no charge to you. How about college and high school, free? How's that sound? You got a baby on the way.
I was gonna start taking GED here,
You want your baby to go to school?
Yeah.
College? High school? Said yes?
but yes, ma'am.
Well, then you be the example. And let me tell you, sir, parental termination in this state is alive and well. You want to have this criminal history? The state can come in and take that baby from you. Mom can raise it as a single mom, and they can terminate your rights. So if you continue on this path, that is one thing that may happen depending on the circumstance. So I suggest you start cleaning up your life now, and you show me that you are up to living in this community, keeping it safe, no criminality, don't violate, show up. You got a problem, you make a phone call. We are not here to punish you, we are here to help you. Now, there is punishment. Being in jail is a punishment for not following these orders. Being on probation, being on bond is for your benefit. So you can start to rehabilitate and to show us your character. So that can go up, it can go down. Decide the path you want. So I'm doing this against the people's recommendation, against what your file says. So you can choose what you want to show me. You can stomp on this gift, or you can use it. I will take that into consideration during this pending situation. Do you understand?
Yes, Your Honor.
And if there's a third file, there is no bond. It just is no bond, no bond, no bond. Don't care if your baby's on the way. Don't care what happens. It's all up to you. All I do is open the door. You decide if you want to walk through it and what road you take. Am I clear?
Yes, Your Honor.
Any questions about what I mean?
No, Your Honor.
No contact means no contact. She doesn't exist in your world. No Hallmark cards, no flowers, no Christmas cards, no messages through carrier pigeon, smoke signal, third parties, or in any way. Do you understand?
Yes, Your Honor.
End up at the same Myers you live. I don't care what's in your cart. I don't care how long you shopped. You go to a different Myers. End up at the same church service. I don't care if it's Christmas Eve mass. You walk out. You do not wiggle an ear, raise an eyebrow, or do anything. You just do an about face and you leave. Is that also clear?
Yes, Your Honor.
Clear, Your Honor.
Understood, Your Honor. Thank you.
You'll receive copies of all of this. Thank you.
Thank you.
Thank you, Your Honor.
And that, just for the record, let me go back on the record, that is what I've read is for both files, not just the one.
No, you did not.
Yes.
Yeah, it's on that. Yeah, you can take this over. You can just give, I'll get it in a second. You can give it to her though.
This is.
That's your high coat.
All right, this is docket 25-4308 FH, people of the state of Michigan versus Patrick Eichholz. Counsel, your appearances for the record.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Good morning, Brian Jackson, on behalf of Mr. Icos, who is present in custody for sentencing.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Have you had enough time to speak with your attorney? Here, put your hand down.
Yes, Your Honor.
And have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, I'm not. I have stopped taking it.
Okay, is it anything that would interfere in your ability to understand your attorney or the court?
No, Your Honor.
All right. And do you have any sign of fever, COVID, or other illness?
No, Your Honor.
Thank you. Have you read the pre-sentence investigation report?
My attorney went over it with me.
Okay, maybe you spent enough time going over it with him?
Yes.
All right, if at any time you need to speak with him, just let me know and we'll take a break off the record. All right, and you pled guilty to operating while intoxicated, impaired, controlled substance, third, punishable by 5 years. Do you recall that?
Yes, Your Honor.
All right, on behalf of the people, any corrections, additions, deletions?
No, Your Honor.
On behalf of the defendant?
No, Your Honor, just maybe on the marriage section, we can add an age for the other child, Grace Icos, being 14. Right now it's listed as no age. That's
Okay.
on page 8.
I mean,
Or-
so he's got Leanne, age 2,
Correct.
and what's?
Grace,
Leanne? Yes, but what's, is Leanne's last name, I hope?
yes, Your Honor.
Okay, because they omitted that too. So I've added her last name and I've made Grace 14. Any other corrections?
No.
As to the scoring on behalf of the people,
No corrections.
Mr. Jackson,
No corrections.
thank you. And on behalf of the people, what would you like me to know?
Thank you, Your Honor. We would just ask that you follow the recommendation.
Thank you. Is there any restitution for this?
None that was submitted to our office, Your Honor.
Okay, thank you. Counsel?
Thank you. Mr. Ikos has been in jail this term for 152 days, plus 2 days makes 154 total days for this. Mr. Ikos, this incident happened back in July of 24, so a year and a half ago. It was a moped, OWI. And Mr. Ikos doesn't have a car and he doesn't have that moped anymore. He has been in jail and has done a lot to improve his position, improve his mental state, and improve his well-being. First, he attends AA every week with Frank from the East Club who comes in. He also is enrolled in Seeking Safety, has done a half a dozen classes there that deals with grief, loss, and makes plans to change his life. He is very enthusiastic about religion and Bible study, where he goes once a week. Your Honor may have read various, I guess, writings and mentions of his Bible studies and scripture. He takes notes on that, and every time I talk to him, he has things to say related to that. He thinks that is one of the best things that's helping him is his religion and his faith, and he plans to continue that wherever he is. Moreover, Your Honor, he would live once he's released in the rescue mission. The new one, as Your Honor knows, there's been updated capacity right near here where they help with receiving Section 8. He plans to volunteer there and attend their Bible study because the rescue mission is somewhat faith-based, which Mr. Ikos would fit right in on. We did read that there's a recommendation for TRICAP. We would ask that you hold that consideration for if anything happens, which we don't expect it to. Again, Mr. Ikos is here for alcohol. There is no history of meth or other types of hard narcotics. Mr. Ikos would appreciate and request to be put on general probation. His criminal history is a little spotty. His most serious offense is a prior OWI back around 2020, where he did attend Judge Allen's sobriety court, and back in district court, Judge Allen refused to take him again, and we're here. We're not so worried about the jail recommendation. Well, there's no jail recommendation, but he's done enough time for the statutory requirement. And he insists that he has learned things during his 154 days in jail, and that inpatient would not be necessary for him. And again, not that Mr. Ikos plans on drinking or driving again, but he doesn't even have the ability to drive, given that he doesn't have transportation, he doesn't have his moped, and he doesn't want to consume alcohol. I would leave any remaining comments to Mr. Ikos.
Thank you. Sir, what would you like me to know?
Your Honor, I have definitely improved my faith with God and my understanding in AA literature. I remember page numbers to look at. The other, one of the valuable things from rehabs in the past I learned was visual aid work. You know, over the last, since I got this offense arrested in 2024, I was learning the Catabus system, and while riding around, I like to, I have figured out a color coding preventative for relapse. I noticed that the liquor store is the main thing. And the signs, the names of the signs are red. To me, that means stop, don't go in there. There's things in there that are gonna get me arrested. Also Myers, their name of their signs are red, and they have red and blue. And it reminds me of police lights. If I look out before I walk in that door to remind me that there are beverages in this store that will get me in handcuffs in the back of a car with red and blue lights. Also, Speedway is that way. They have red and blue colors on their signs. And Walmart and Kroger's blue, state police cars are blue. The boys are blue, my suit's blue. The other thing that I've been thinking about is getting a red and blue ring for these fingers, because I pull my wallet out of my back pocket. Perhaps visual aids will work. That's just my method to color coding. It's way easier than trying to remember to pick up the phone. And that could lead me into picking up a phone as well, but also there's, I have been gifted by the county jail in the state of Michigan, a state ID, which I lost over this last year, or over, well, when I was homeless, I lost my wallet with my social security number. The county also gifted me a birth certificate. And back in August-ish of this year, I applied on the kiosk for Manpower to get a job. That's where that's at.
When was the last time you worked?
Well, when I was homeless, I had an elder gentleman that allowed me to stay with him. He'd been helping me out. I cleaned his house up for him. And then when
How about a paycheck where you pay social security and all that?
it's been a long time.
How long?
Probably since 2016.
What'd you do at that time?
I had went from lawn care to factory work.
That'd be a good job. Can you go back to do that?
I can.
What kind of factory?
I've done CNC work, assembly, inspection, grinding, packaging.
Sure, those are all desirable jobs. You make good money, you'll have a retirement.
I've written that down. I had that in I do have that in consideration. And second or third shift seems to be where I think would fall in line for me. So I could do my classes or AA meetings in the morning, and testing as well.
So what step are you working on?
I know that I'm an alcoholic. Page 30, 31, and 32 in the big book explains at the end, the first two sentences on page, or the end of the first 2 or 3 sentences starts out that try controlled drinking, which I've done that. An real alcoholic can't have 1 or 2 and just stop. Also, I know that by my own choices over these last quite a few DUIs. And the last time I realized, well, I'm on step 1, 2, and 2. I do have a higher power of my understanding, which is love, patience, kindness, forgiveness, gentleness, self-control. Now the Bible, there's a lot of verbiage, I guess is what I've heard it called, is who my higher power is, or Holy Spirit is. Also, there's Bible verses that I have memorized. Do not get drunk on wine, for this causes debauchery. Debauchery is chaos for the community, my family, myself. Be filled with the Spirit. There's a proverb that says, do not get drunk on wine, for this causes wine is a mocker, strong drink is a brawler. Whoever's led astray by these is not wise.
Okay, let me just stop you there, sir. You have had some trauma in your childhood.
Mhm.
And I think I read that you've chosen to look at the happy times and not the crap you went through. Let's put it that way. But those kinds of things and other things we all suffer through as human beings. No one's life's perfect. Seem to bubble up. You have to deal with them. Have you ever gone through any counseling to deal with those things?
I have, I think
And
the valuable thing that I learned from, forget her name, but she was, at a counseling course. Well, anyways, she said that write these things down because they're in your mind. Because if you don't, they just rotisserie, they're rotisserie.
right, and that's what I'm asking. If you had a 0.186, that is a sign that you're an alcoholic, but it also, to me, is a sign that when there's a problem, you didn't ask for help, you reached for a bottle. So I'm thinking you also need to continue some trauma counseling or therapy. How do you feel about that?
I'm learning to I let go of that, I've let go of that. I wrote down,
Sir, I don't think you've let go of it. I think that you've immersed yourself and you know, God seems to live over in the jail. I think you've immersed yourself in religion, which I'm totally supportive of, okay? I think that, you know, you found the value in AA and those teachings, totally supportive of that. But all of that does not answer or relieve you of some of the pain that you've been trying to shove down all these years. You don't have an OUI third, and it's probably more than that. I have to look at your history again, but you don't have this history without that stuff bubbling up. So I'm gonna put you in some additional therapy.
okay,
Now, I don't know if it's gonna be 2 meetings and the therapist says, you're good to go, or 20 or 50. I don't know what your underlying issues are, but until those get resolved, this is gonna bubble to the surface and you're gonna struggle. And you can do all the reading you want to, but sometimes those demons take a hold of you and we're right back here. And I don't want that to happen since you've come so far. You're a lot farther than most of the people I see. In acknowledging you have a problem and you've got some goals and all of that. But I want to make sure that we don't have a crack in your foundation, and that crack would be the demons that you have said, well, I'm just going to look at the positive and leave the negative behind. It's not as simple as that. Okay, are you good with that?
I am, Your Honor, thank you. The other thing is to carry around the bit wherever I work at, to carry around the Bible and the big book with me. So when I'm on breaks or if I need to take a moment to open them up and reflect, that's the other thing I have written down and have burnt into my mind by this correctional experience, journey.
All right, thank you. You're going to be on probation for 24 months. You have to at least do half of that before you're released. So if you're doing really well, I'll release you early. If you're doing poorly, I'll put you on 36 months or the full 5 years. Just depends on how you progress, okay? Sounds like you're gonna do well. You already have a really good start, but I don't know. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, drug paraphernalia, no marijuana without a prescription. You will be tested, not adulterate any test. And if you miss a test, you will do a secondary test. If the test is positive, you will also do a secondary test so we can see if it's false positive. You will attend AA, NA, or CA no less than 3 times per week. That can be adjusted based on the recommendation of probation, your therapist, any program that you're working with. It can go up, it can go down. I want you to have a sponsor who has been clean and sober for at least 5 years and got that way through a program. Now, if you find someone who has less than 5 years, that's fine, but you still need someone with 5 years. There are many people that have multiple sponsors, all right? If at any time you're referred for outpatient or residential substance abuse program, you will comply with that, and I'll treatment requirements, including aftercare. I will hold in advance for now, TRICAP, Residential Substance Abuse Program. However, if you are positive, if you end up struggling, that still is on the table. You will complete therapy that will include cognitive, behavioral, and trauma therapy, as well as substance abuse. You'll sign all necessary releases and complete all aftercare. You will wear a scram tether for 90 days, and you should be able to qualify for the indigency grant. That can be extended or decreased based on how well or how poorly you're doing by probation. You'll obey all court orders and recommendations from all treatment providers, those become orders of this court. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Correction who's on parole or probation, unless you let probation know and everybody's in good standing. So you may attend group or other things with probationers, and that's fine, but any personal contact that you may have, we need to know, so I can give you permission, and you only have that permission as long as everyone's in good standing. You will contact probation within 24 hours of your release from jail. You'll comply with all written and verbal orders of probation and all treatment providers. Those are the orders of this court. You'll allow probation in your residence at any time for probation supervision without a warrant, and submit to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer, if there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest, personal protection order placed on you. Police contact, loss of employment, or change of residence within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday. If Monday's a holiday, tell us on Tuesday. You will be part of a work-seek program and make genuine efforts to find and maintain legitimate employment, a minimum of 30 hours per week unless you are in a school program, and then it would be a minimum of 18 hours per week. And that would be as a full-time student. You can work more, you just can't work less, and you will not give any employer any cause to terminate you. You will pay restitution in the amount of $475.64. That goes to the Ingham County Sheriff's Office. I believe that is a total of two amounts, and those amounts were $125 and then $350.64. You'll pay a crime victims assessment, the amount of $130 and $68 state costs. I'm waiting fines and costs, finding that you're indigent for that. As to the crime victims and the state costs, that will be paid after the restitution. And probation will not be held open because you've not been able to pay. So if everything else is done, and I don't hold you open, I don't hold probation open because you're indigent. So we'll get our money a different way. Comply with DNA testing unless it's already on file. I believe it's on file because this is a third offense. You will not use any object as a weapon. You'll not own, possess, or use any weapon as an object. You'll not have any guns, imitation of a weapon, ammunition, any kind of firearm in your possession or in your presence. If you walk into a friend's house and they have contraband, you just do it about face and leave. You will serve 365 days jail with credit for 154 days served. The balance of the jail is held. I can use any or all of that time while on probation. You will not operate a motor vehicle. You'll follow the Secretary of State rules. I believe there's, if you have a license, it would be hard suspension, and then you might get a restricted license, but don't You don't have a vehicle anyway, right?
No, Your Honor.
All right, so, there's also mandatory vehicle mobilization, which you don't have, you got rid of both vehicles that you have, right? So that's really not an issue for today. And you will meet with probation at the frequency they want you to meet, and if for some reason you're ill, a lot of influenza A going around, you're ill, you can't make it, you chase them, they don't chase you, so you let them know you can't make it and reschedule, okay?
Sure.
Is there anything I've told you to do that you can't do?
No, Your Honor. May I have a printout or a paper copy?
You're gonna be going over this with probation, so I say it on the record, and then it's gonna be reduced to a writing. They'll go over it with you verbally as well as giving it to you. I know it's a lot, you don't have to do it all. Understand?
Remember a few things, yes, Your Honor. I remember a few things. I can write them down.
You what?
I said I can remember a few things, but I can write them down too. So.
Well, you have to, as soon as you get out, you gotta find a ride back here to go to probation. Can you do that?
Yes, Your Honor.
Okay. And sir, I know you're going over to a shelter, but each and every time you switch, you're gonna have to let us know where you are. And hopefully we can work on getting you some housing.
Your Honor, I understand all this. Yeah. They help.
So hopefully they'll help you get housing, but I don't know, there's a big homeless issue in this community, so I don't know.
I've heard, Your Honor, that they do allow the lobby to be open to sit in overnight. So if there's not a bed there may be that opportunity.
I know, and there's code blue and there's lots of things going on now, but if you get caught in a situation where you have to go to a different place, then we need to know where you are, okay? And hopefully getting a job, you can get your own place. Okay, and there are probation, there are agencies that will help you, okay? So I'm hoping that through this probation, one of the goals will be that you get a house, a job, stay sober, have a sponsor, do all the things you're supposed to do and get on the right track with your life. Now, what about your children? Are you paying child support?
Not yet, Your Honor. I haven't seen them in a while. I miss home.
Well, whether you see them or not, the mothers owe child support. Are there court orders for you to pay or no?
Not this time, no. As far as I know, the mothers have told me they don't want us.
Okay. Understand
There's no-
that if they file for child support, you will also be required to follow that. And if you don't pay, there'll be other charges that the Attorney General will bring. Do you understand? So once you're working, you do need to pay something.
Where do I go to do this?
Well, you work out with them. If they don't want the money, that's fine, but I suggest you help out where you can. You have 42 days to appeal and to request appellate counsel. Please hand in his appellate rights.
Handed over.
Acknowledge receiving those. If you're unhappy with what I've done, that's what you use, okay? Good luck to you, sir. Thank you.
Your Honor. Merry Christmas.
Merry Christmas. I'll be with you in a minute. I just have to sign a couple of orders. May I see you for a moment?
You're in trouble.
Probably. I do.
Thanks, Nancy.
You're just getting tired.
Ms. Maycomer, if everybody wants to get with me on that, that's fine, but I'm not signing that without the therapist's recommendation.
Okay.
If you could pass that message along.
Mr. Ferguson's right there, so
Yeah.
I think you heard it.
Yes, I heard it, Judge. I'll let Mr. Rosen know. Yeah.
There's no, that is one of the most absurd decisions I've ever heard without a therapy recommendation. So y'all want to come in? I will come in. I'm off next week, but I'll come in, or we can Zoom, or we can do it this week, but that's no, that's a big no.
Fair enough, Judge. I'll talk to the family court and come up.
I mean, this is more for the satisfaction of the parents, not to traumatize children. Not interested.
Good enough, Judge.
Thank you. What do we have? Is this Mr. Brown?
Yes, John.
This is docket 24635 FC, People of the State of Michigan versus Golden Allen Brown. Counsel, your appearance for the record.
Good morning, Mayor. Natalie Maycomer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender on behalf of Mr. Brown, who stands to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am, I do,
Thank you. Put your hand down. Have you taken any medication yesterday or today?
yes, ma'am.
Is it anything that would affect your ability to understand the court or your attorney?
No, ma'am.
Is there medication you're supposed to be on that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
I have.
All right, thank you. And I understand this is a final pretrial, is that correct?
Yes, Your Honor.
It is.
And what is the offer?
Your Honor, at this time, the offer in the file is for the defendant. Three, guilty asked to count 2, which is home invasion first offense. As a habitual fourth offender with a fixed 20-year sentence. Mr. Freeman and I did speak this morning, and we did talk about a fixed 15-year sentence that people would consider, but it's my understanding that both of those have been rejected.
And then, so it'd be count 2, which is a 20-year felony with a fixed 15, so it'd be 15 years to 20 years. And then counts 1, carjacking, which is punishable by up to life, would be dismissed. Police officer fleeing, 4th degree. Under the motor vehicle code, a felony punishable by 2 years would be dismissed. Count 5, similarly, a police officer fleeing, 2 year would be dismissed. Driving reckless, 93-day would be dismissed. Driving reckless, 93-day misdemeanor would be dismissed. And again, a police officer fleeing, 2 year would be dismissed. And there's the habitual offender fourth offense notice. And that's a mandatory 25-year sentence on the carjacking, which would be up to life. So is that full?
Yes, Your Honor, the mandatory 25-year minimum habitual offender notice would be dismissed, but we would have the original habitual offender fourth offense.
Oh,
I think too.
I got you. Okay. So, counsel, is that full, fair, accurate, and complete?
It is, Your Honor.
Is that full, fair, accurate, and complete, sir?
Yes, ma'am.
And counsel, is his intent to plead and accept it or not to?
He would like to thank you, respectfully reject the offer.
Is that true, sir?
Yes, ma'am.
And did anyone force, threaten, or coerce you to make that decision?
No, ma'am.
Did anyone promise you anything that caused you to make that decision?
No, Your Honor.
And you made that decision after talking with your attorney, looking at the evidence, discussing all the different options?
Yes.
And you spent enough time with your attorney? You sort of hesitated and you said, yes. Did you need more time?
No, we discussed what needed to be discussed, and I think he's gonna come to the jail when we further discuss it.
Well, there's no further discussing this. This is the final free trial unless you want to discuss it right now. There's a free trial. There's a lot of time that goes on, a lot of negotiations, a lot of work that you all do. And then there's a final pretrial. It's a file called final, not final.
Well-
So, and I do that, sir, not necessarily to pressure you in any way, except that I have a lot of people that get to trial. And what happens is that people, they see the jury and then they say, crap, I should have taken the deal. Can I take it now? And the problem with that is that now somebody else has been deprived of their jury trial because notices and all of that haven't gone out. And so we lose a week on my docket of trial and somebody else loses it. So that's why I have these cutoffs, because I need to get people like you to trial. So this is the day. If you need more time with your attorney now, I got time. I've got other cases. You can talk to them now. Otherwise, this is a final pretrial.
Yes, I see just by your desk that you're a very busy person, and I don't mean to hold up anything. I'm a little bit hesitant answering yes or no right now, because I thought this was a status hearing for the diminished capacity defense, where we were waiting for forensics to come back with the
Didn't we
report.
already have forensics or no?
We did the competency hearing, but we didn't have no hearing on the diminished capacity, and that's what I was talking about him with. And that's why I was hesitant, because I spoke with Mr. Freeman this morning about, it looks like we're just overlooking the diminished capacity defense, because I was on a medication olanzapine, Zyprexa, and I came off of it not weaning like I was supposed to, because I didn't know. And I had a brain zap. I mean, it's clear. And that's why I was hesitating, surely not to hold up your docket, because you're
Well,
very.
wait a minute, so did he not, so we have competency, but did we ask for the other criminal responsibility?
They did the hearing, but I mean, there was no discussion in the courthouse, and I didn't know if that was supposed to take place.
Well, I don't usually get that document. Did we receive that, Mr. Freeman?
We did receive a report, Your Honor. I don't believe it addressed an issue of diminished capacity.
And I do have a notice of insanity defense here.
That was in order to get a review of criminal responsibility. And those are no longer issues.
So I only have the one report. We received the other one and there was no finding?
He was found to be competent and
Competent at the time of the offense?
yes, positive and possessive of criminal responsibility.
And going to trial then, are you considering bringing experts in regard to what his claim is on the medication?
If that is the defense that is ultimately decided on and it would go forward in that direction, that would probably be necessary, yes.
Okay, so sir, that's apparently the text that you're, and I don't need to go into all of it, and that's between you, all of you, I don't need to take their defense and present it to the people any further, because that's not my job, and they don't have to disclose all of that, but apparently they are addressing your concerns, so it's up to you if you wish to take the agreement or not.
No, I would just,
Okay, did anyone force, threaten, or coerce you to make that decision?
no,
Did anyone promise you anything that caused you to make that decision?
no, Your Honor,
You're making that decision after talking with your attorney and considering your options.
I am.
Court is satisfied. Do we have a trial date?
Our trial date was not previously set. The next date that would work for the parties is May 29th of 2026. With a final pre-trial of May 6th.
We already had our final pre-trial.
I'm sorry, yes. May 29th of 2026.
Now, if something changes when those experts are contacted, let me know. We can reopen the issue, but at this point, not having any information, that trial date will stand. Does that work with your schedule, counsel?
Yes, Your Honor. Thank you for asking.
Great, see you then.
Yes. Things happen when you're downstairs. That's all right.
Your Honor, I've had my fill with Mr. Freeman. He's lied to me. He's done so many things to me. I have a letter right here that I would like to give you that I wrote concerning Mr. Freeman and his dishonesty. And
Okay, Mr. Ring, please see the letter, or grab the letter so I can see it.
I would like Mr. Freeman to remove my case.
All right, stop, sir, stop,
Yeah.
stop,
We're not
stop.
on the record.
Let's go back on the
All right,
record.
give me a second.
You can make copies of it right now too.
Stop talking, sir. Contempt is 93 days.
Yes, ma'am. I apologize.
Yes.
Yeah. That's it.
All right, sir, please get up the podium. We are back on the record. All right, you've just handed, I'm sorry, are you ready, Nancy? You've just handed me a letter along with the substitution of counsel, saying that you are unhappy with Mr. Freeman. I did want to tell you that I heard once we got off the record, and now we're back on, of course, but that you were asking him about bond. Sir, you are pending a mandatory 25-year felony. It's not the practice of this court to give people who have a mandatory 25-year felony bond, because safety of the public, you have a life offense, there's multiple counts, and there's every reason for you to flee. So he can make he can do cartwheels around the courtroom and beg me to do, and to give you bond. I'm not likely to do that. And the requirements that I have to consider are safety of the public and your safety. And given the history here and the habitual, I'm not likely to do that. So if that's your unhappiness, and there's no attorney that you can, there's a dozen attorneys here. You can pick them up. They're all really good. They can come here. I'm going to have the same result. Second, you mentioned a whole lot of other things. You're not happy with them. I'm going to grant your wish, because apparently you two can't work well together. He's working well, fine with you. He just told me, but you're unhappy, and that's your prerogative. Not every personality you get along with. So I'm going to, Mr. Freeman, I'm going to thank you for your service and discharge you. We're going to get you another appointed counsel. This does not mean, however, that you get your choice of attorney. This does not mean that we're going to go through a whole battery of attorneys, because we don't have that, and you are not entitled to your choice. So I hope you get the next one who will work with you, but you got your wish. Anything else?
No, ma'am, I felt I was being pretty patient, waiting as long as I did, because he came out of the gate dishonest. If you'll read that letter.
I'm not going to decide on his honesty or dishonesty. He's never been dishonest to me. I can tell you that 90% of the people who come out in jumpsuits tell me they got a problem with their attorney. They didn't listen. They didn't do this or that. I'm not here. I'm not the state bar. I'm not going to listen to that. I've already released him. So I hope that you and your next attorney work well together. I only know Mr. Freeman and the rest of the attorneys who appear in front of me as honest. If I did not, I certainly would report them.
Thank you. I'm
So You've got your wish. We don't need to make a further record on that. Any objection on behalf of the people?
No, Your Honor.
Thank you.
Thank you, Mr. Freeman.
Is the trial date standing?
Trial date stands. There's plenty of time to prepare for this case.
I don't know if I ever want to.
Give me a second here.
That's worse.
No, it's just making sure. No, civil supervisors.
So who else do we have?
We've got a lot left.
We do. It's not.
We've got a lot left.
Okay, I have a judges meeting, but apparently I don't have to go. What else is
We've
left?
got quite a few left.
Are you Mr. Hanks?
Yes.
Mr. Starks here, who's it? Oh, there he is. All right, this is docket 25-516 FC, people of the state of Michigan versus Siobhan Michael Hanks. Counsel, your appearance for the record.
Good morning, Nicole Winters on behalf of the people.
Good morning, Your Honor. Jacob Sarge, the fourth assistant public defender here on behalf of Mr. Hanks.
All right, he also has a second file, 256018 FH. This is a final criminal pretrial on 25-516 and a bond hearing on 516 FC. What's going on?
Your Honor, as to the final pretrial, Mr. Sarks and I have continued negotiations. He provided me with additional information this morning. I also, as I was looking into the bond violations, provided him with some information. So we are hoping to set the final pretrial for March 11th of next year with a jury trial date of April 24th of next year. I have confirmed with your docket prosecutor that those dates are available. And I've also confirmed with Mr. Sarks, they should work with him. He should work with what? His candidate.
Okay.
That's correct, Your Honor. So I'm in effect requesting that we treat this as a continuation and have a final pretrial be finished up in March, Your Honor. We've been negotiating extensively here for a global resolution. Mr. Hanks has case 25-006018 FH that's also scheduled before Your Honor today. Mr. Foreman is the attorney of record in that file. I'm covering it for Mr. Foreman. And we anticipate, Your Honor, that if we do reach a plea deal, it will be a global resolution involving 25-006018 FH in addition to 25-000516 FC. Further, Your Honor, there is another matter which might be under investigation from what I understand that relates to the bond violation allegations here involving the tether. And that is something we will also be attempting to negotiate too as part of any global resolution, Your Honor. Thank you.
Sir, please raise your right hand to swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury.
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes.
Is it anything that would interfere in your ability to understand the court or your attorney?
No.
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had no time to speak with your attorney?
Yes.
Thank you. In regard to bond, what is, on behalf of the people, what would you like me to know?
Your Honor, Mr. Sarks did file a bond motion in this case. I do want to bring to the court's attention a few things. At the time of this offense, this defendant was both on felony probation for breaking and entering a building, as well as bond for a pending criminal sexual conduct that he has since pled to. That was when this case first came to light. I was comparing the bond motion that we had in July to the one that was filed by Mr. Sarks, who was always very thorough, and noticed that all of the justifications for a PR on this one, or most of them, are included in that one as well. For example, that he will reside with his mother on Bench Street. Well, this morning,
what street?
Bench, thank you. This morning I provided Mr. Sarks with a jail message where Mr. Hanks threatens to kill his mother. Now, it could be hyperbole, but it's clear that that relationship is not a solid relationship for him to be supervised in the community. He also indicated back in July that he wanted to pursue substance abuse treatment, that he would go to RISE, that he would obtain employment, that he wanted to further his education. That's consistent with the bond motion today. So in July, this court heard the bond motion, gave Mr. Hanks a chance, granted him a PR bond. He was released on July 31st on a GPS tether. On August 4th, he violated the exclusion zone twice. He then cut off his tether, and that tether was recovered by the tether company. And then he was arrested, and he gathered the new charges that is before this court as well. Nothing has changed in this case since the court granted him a PR bond. If you look to the bond report that was provided by pretrial services, he has multiple fails to appear. Many of the information was unable to be verified, such as his residence with his mother, his work, his employment. They note that he has a history of non-compliance under the criminal justice supervision and that a PR is not recommended.
Are you telling me I'm gonna end up with a third file?
Your Honor, I believe he could for for cutting the tether. That's one thing that I told Mr. Sykes. I will reach out to East Lansing Police to see if that is going to be sought.
Is there any other that you know of pending?
I did not see anything else. He was only out for 5 days. Then he picked up the possession of cocaine. He indicated that he wants to address his addiction. So I will say, I went through some of the jail messaging. He's doing classes in the jail. He's doing things to hopefully better himself in the jail that he quite frankly was unable to do in community supervision. The victim in this case is a stranger. Stranger. She is absolutely terrified to have him released. It's clear that we cannot have him in our community, certainly not on a PR bond or a lower bond. He's not being held on no bond. He's being held on a $250,000 cash surety with conditions, I believe, set by this court to include that GPS tether with victim notification, which is absolutely what we want if he is ever to post bond. I do not believe Mr. Hanks is an individual for community supervision. And we would ask that the motion be denied.
Thank you, Your Honor. First of all, I would just note that Mr. Hanks is 21. It's my understanding as it relates to that comment about his mother that was taken out of context when I was in relation at a time when he was very upset with his mother. And it was in the context of communication with a sibling of his. And obviously he doesn't mean any of it. He was just very upset with her at the time. And he put down something allegedly, according to the JML, that was turned over by the prosecutor, which clearly was taken out of context and is being misconstrued at the moment. From what I understand, Mr. Hanks has a good relationship with his mother now. Whatever issues they've had, they've cleared up. Obviously, it's been a journey for him, and he's had some ups and downs with his mom over the years. But from what I understand, if he was granted another opportunity, Your Honor, he would have a stable place to stay. He's a smart, capable young man, Your Honor. He just has been struggling with opioid addiction since he was about 13 or 14 years old. And I'm not going to ask for a blanket community release, Your Honor. What I would respectfully request is that he be ordered to attend inpatient treatment as part of his bond. That be a condition. And that we'll try to coordinate with Maria Klockner, my social worker, who's been working extensively with Mr. Hanks about trying to find a bed space for him. And then once a bed space opens up, Your Honor, we'd request that he be allowed to go to inpatient treatment at that point. That is what I'm going to propose for Your Honor this morning in terms of a bond amendment here. No question, Mr. Hanks had some struggles when he was released last time. He's 21. He made some very ill-timed and foolish decisions, Your Honor. But of course, he's presumed innocent on the accusations involving the tether and everything else. But at the same time, he understands he messed up, Judge. You gave him a wonderful opportunity with the PR bond. He made some poor choices, but at the core, this goes back to his struggles with opioid addiction, especially OxyContin and Xanax, Your Honor. He's been, very candid about that. He wants to get the help. He wants to get the treatment. That's a big reason why these plea negotiations have been going on, and as long as they have been, Your Honor, as we look for ways potentially to try to resolve this case, and that's going to be the linchpin of the negotiations on the defense side, and make sure that if we do work out something for Mr. Hanks, he's presumed innocent, certainly has his right to have his trial, but that treatment be an important part of his rehabilitative programming. So, Your Honor, I'm not just going to ask you just to let him out to go on the streets. What I would propose instead, Your Honor, is that if we can get him a bed space, that he be allowed at that point, and he's indigent, that we wouldn't have the money to post any cash bond. Further, his mother's also indigent as well. The family's very strapped financially, that if we can get a bed space for him, Your Honor, that he be granted a PR bond under those circumstances, so he can be transferred there, potentially if Medicaid or other sources of funding can pay for it. And that way he can get some of the help that he really wants to pursue in a more therapeutic setting than the county jail. Thank you, Your Honor.
Without talking about any pending case, what would you like me to know, if anything, sir?
I apologize for all the times that I messed up the chances you've given me. I'd love a second chance back into society and a chance of getting help.
I appreciate the apology, sir. (2024) retail fraud, Hyder revoked. 2024 defrauding innkeeper, 2024 defrauding innkeeper. Now, a lot of these were nully crossed, but it speaks volumes as to your state of mind in our community. 2025 CSC force, computers using to commit crime. 3 counts of that, indecent exposure, 3 counts of that, retail fraud, disorderly person, 3 counts of that. Home invasion, 3rd degree. Most of those were dismissed or now processed as part of a plea agreement. And then pending, we have possession of a controlled substance less than 25 grams. We also have pending armed robbery, weapons, dangerous weapon.
My apologies, Your Honor. Can we just approach quick?
Yeah. Okay, I guess it's fine. Yeah, this needs to be corrected.
Thank you.
Nonetheless, you're indicted on a couple of other charges. We've got allegations now of armed robbery, weapons, carrying with unlawful intent, weapons, felony firearm, pneumatic gun. Sir, you have no idea how many gun charges I have with kids your age and younger. And kids are dying on the streets every single day in our community. You may be sorry that you violated the bond conditions and you're innocent until proven guilty beyond reasonable doubt. But I look at this extensive history and you have a lack of regard for your safety, your life, the lives of others, this community, and I understand having those fights with your mother. I have teenagers who fight with me all the time and say things they don't mean. But, sir, it's still frightening and uncalled for. Your mother opens her home to you and you disrespect her, and I really don't care the reason. You need to learn to hold your temper. I am not releasing you. I gave you a chance and you threw it back at me. I understand your brain is still developing, but I also understand that you are doing more positive things in the jail than when you're out. I don't want the continued list. You need to learn, you need to grow. Everybody makes mistakes. It's what you do with those mistakes. So you can be mad at me. That's fine. That's my job. I'm not in the happiness business. I'm hopefully in the rehabilitation business. I am hoping that the mistakes that you've made, you learn from, and you decide that you don't want to be a jailed man, that you want to be a productive, free man. Because God gave you all those gifts when you were born. Your mother birthed a healthy baby, a handsome baby, a smart baby. Now, what you do with those gifts is up to you. You can take all that talent and keep it in jail or prison. or you can show the community that you are made of really good stuff and you make amends. Because none of us are perfect. We all make mistakes, me included, but it's what you do, the lessons you learn, how you go forward. That defines who you are. That defines the man you are and who you will become. So your bond motion is denied with a message to keep doing well in the jail. Maybe eventually I'll change my mind, but we need to get to trial. We need resolution on these. We don't need any more new files, and I don't need any more bodies in this community because there's guns. So to keep you safe, the community safe, and to keep you on a learning path, the motion's denied. However, in jail, you will work on your GED, AA, NACA therapy, and continue on a positive growth path. That is the best gift I can give to you, even though I know right now, at your age, in this moment, you don't believe it's a gift. Denied, that's all.
Thank you, Your Honor.
Next. I don't know what's right. Is it okay?
Want you to know.
Is there anything that's a plan?
I don't know.
Do we have anything else? Oh, okay.
Yeah, we do have to express-
Do we want to do the joinder?
Rich said Howard.
You're still on that.
Oh, you're still doing that?
We already did have.
That's good.
No, we didn't.
We did Howell.
Howard's a sentencing.
Oh, kill me if these names are the same.
It's not me.
Welcome to my world. Here you go. So you want the one I ripped?
Yeah, I do actually, because I wanted to read the rest of it. I read some of it. I read some of it.
That's not happening. I signed it and I'm like, what the hell? What? Yeah, no. Yeah. This is docket 24-1005FH. And this is the people of the state of Michigan versus William Richard Howard. Counsel, your appearance for the record.
Good afternoon, Your Honor. Natalie Maycomber on behalf of the people.
Good afternoon, Your Honor. Toby White on behalf of Mr. Howard. Mr. Howard is with me at the podium.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, ma'am.
Thank you. You may put your hand down. Sir, have you taken any medication yesterday or today?
No, ma'am.
Is there medication you're supposed to be on that you're not on?
No,
Any sign of fever, cold, or other illness?
no.
Have you had enough time to speak with Mr. White, your attorney?
Yes, ma'am.
And have you read the pre-sentence investigation report?
Yes, ma'am.
Sir, you pled no contest to assault with intent to do great bodily harm less than murder or by strangulation with a habitual third that's punishable by 20 years. Count 3, assault with a dangerous weapon, also known as felonious assault with habitual third, punishable by 8 years. Count 9, weapons, felony, firearms, punishable by 2 years, and that would be consecutive with the preceding any sentence that you are given on the others. And over all of them. Nope. And then domestic violence, a 93-day misdemeanor. Do you recall that?
Yes, ma'am.
All right. We have a victim here who wishes to testify
No, Your Honor.
on behalf of the people.
Thank you, Your Honor. The people just ask that the court follow the agreement.
Thank you. Mr. White?
The same thing, Your Honor. We'd ask you to follow the agreement. We worked pretty hard on putting this together, and I think it's appropriate. And I would just ask the court to, excuse me, recommend continued substance abuse counseling during this period of time. Obviously, this is what's involved here. His mother's in the courtroom. He's not bad at heart, but he's got to get this stuff under control and figure out what the motivations are. And then when I think he comes out, he'll be a productive citizen. And I guess I should say for the record, I have no changes to the body of the report or the scoring.
Okay, and the people didn't either.
That's correct, Chairman.
And I noticed that the recommendation from probation would be on count 2, 57 months. The plea agreement was a total of 5 years, which would be the 36 months plus the 24 months, which is consecutive and preceding, correct?
Yes, Your Honor.
That's correct.
Okay, so it's a total of 5 years, so they just didn't read the agreement. So I have corrected that. All right. Sir, anything you want me to know?
No, ma'am.
All right, thank you. Sir, as to count 2, you will serve 36 months to 240 months with credit for, I guess the credit's gonna go on the other, so there's no credit on that. Count 3 is assault with a dangerous weapon. You will also serve 36 months up to the 8 years. And counts 2 and 3 will run concurrent. As to felony firearm, you will serve 24 months consecutive and preceding the 36 months for a total of the 60 months, which is the 5 years as per the plea agreement. And you will receive on that count, is it 400 days? Because they have 400 days, which is a total of the 397 and the 93. Is there some, or 307 and the 93? Is there some reason they didn't? It should be 400 days, correct?
It should be, yes, Your Honor.
They just did it a little weird. Okay, on the cover page it reads differently.
Yes.
And that's because they gave 93 anyways.
Yeah.
Okay. Nonetheless, he gets 400 days credit on count 9, the weapons, felony firearms. And then the domestic violence is 93 days of credit for 400. So basically that's done. I think the way they broke it out was because the 400 are all gonna go on it. Anyways, I know what they did, but we're just gonna do it like this.
Satisfies
I
me.
think
Your
it
Honor.
makes
Yeah, no,
sense, because otherwise it's gonna mess things up. As to the domestic violence count, he will pay a $50 state cost. As to the other 3 counts, he pays a 68 times 3 dollar amount, and then he pays $130 crime victims. Those will be paid after within 24 months of his release from prison. I don't have him pay during. And while incarcerated, he will attend AA, NACA, substance abuse counseling and treatment, individual and group, if they have it, trauma therapy, including anger management, domestic violence, therapy, as well as, completing his GED and trade school. You know, have plenty of time. I think it's important that you keep busy. Any problem with any of that?
I have learning disabilities and I've tried to get my GED and I don't know if that's gonna be a realistic goal,
Okay,
honestly.
so I'm just gonna put GED if there, or some other training that will help you, because they do have resources with learning disabilities, and can you attend trade school?
I comprehend this. I did get assistance the last time I was in prison with it, and I honestly, I don't.
Okay, so we're gonna make a note that you have learning disabilities that should be considered, when providing all treatment
Okay.
and services, okay? Now, I'm sorry, did you tell me you were on medication?
Yes, ma'am.
Okay, so you should also continue the medication that you're on. All right?
Yes, ma'am.
And be seen by medical. You have 42 days to appeal and to request appellate counsel.
This is your application to appeal, if you're dissatisfied with the sentence, within 42
Right.
days, you have to object. Okay, and then, you have an appointed lawyer. That will take a look at it.
So if you're unhappy with anything, that's what you use, counsel, or sir, do you understand?
I'm sorry, what?
So if you're unhappy with the sentence, or whatever, then you need to use that, and you have 42 days to fill it out. And
Okay.
so because you have a learning disability, you probably want someone to go over that with you and to make sure and see whether you want to sign it and request that or not. Does that
Yes,
make
yes, ma'am.
sense? Okay. Would like to, sir.
Thank you.
Thank you, Your Honor. When first you get this, I think you'll get some- I think it's good. All right. Come on, can you hug it? Thank you. Let's see.
Mr. Oates,
Good morning,
how are you?
Look at we have.
Walker,
This is docket 24996 FH, People's State of Michigan versus Donquist Walker. Counsel, your appearance for the record.
good afternoon, Your Honor, Natalie Maycomber on behalf of the people.
Michael Wilkes appearing on behalf of Mr. Walker.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am. No, ma'am.
And have you had enough time to speak with Mr. Oates?
Yes, ma'am.
Have you reviewed the pre-sentence investigation report?
Yes, ma'am.
You pled guilty to count 1, weapons, firearms, possession by a prohibited person, punishable by 5 years. Do you recall that?
Yes, ma'am.
Any corrections, additions, deletions, and captions?
No, Your Honor.
Counsel?
No, Your Honor.
As scored?
None, Your Honor.
No, Your Honor.
Thank you. On behalf of the people, what would you like me to know?
Thank you, Your Honor. The people just asked me to follow the recommendation from probation.
Counsel?
Thank you, Your Honor. Your Honor, my client also asked you to follow the recommendation. He did want you to know that he completed the gun safety course online. He gave proof of that to the probation officer. He did take his pre-test for his GEDs. And he's ready to move forward with taking a GED test. He did provide a letter of completing 40 hours of community service, and these were various things that the court advised of him at the time of taking his plea. So he does have his letter showing that he's completed 40 hours of community service. He has a letter of support from his employer over at Dakota. and various letters from family members that speak about him helping out in the community. And most notably, you have a Ms. Grubbs who speaks of him helping out with her grandson after her husband was killed, and him taking an interest in the grandson and taking the grandson to boxing lessons and things of that nature, and how he's been a positive impact in her grandson's life. So it's just like the court to take those things into
Have
consideration.
the people seen those?
Yes, Your Honor, the defense counsel showed them today.
Give me your approach, Mr. Oaks, thank you. Sir, what have you learned from this?
A lot.
Tell me.
Okay, basically, like, I really learned that every action comes with a reaction, you know, and it's easy to get in trouble, it's hard to get out of, and I've been on the right path ever since. Like, I've been trying to improve my life with my kids, you know what I mean, because I got a lot of kids. I got a lot. But anyways, I'm just trying to be a good role model for them, you know, where I could be in their life and help them progress in life.
Are you working?
Yes.
What do you do?
I work at Dakota and then
Oh,
at
that's
Tim
right.
Hortons. Yeah,
And then where?
and Tim Hortons.
He's a baker at Tim Hortons.
No, I'm eating some of your food. All right. Counsel, thank you. All right, sir. You are going to pay crime victims in the amount of $130 and $68 state costs, $198 mandatory dollars. I can't wait. How soon can you pay that?
You said, how much is it?
$198.
As soon as I get paid, that'll be like Wednesday.
So you can pay it by February 14th,
Yes, ma'am.
Valentine's Day. You won't forget me.
No.
Okay, all right. Now I'm gonna give you 2 days jail credit for 2 days and the $198 that you'll pay by February 14th at 4 p.m. Hopefully you pay it sooner. You have 42 days to appeal to request appellate counsel. The court will make a record that he has done a lot of things that I would have requested on probation. I gave him early notice that if he did that, I would give him, that I would consider that, and I have done that. Merry Christmas. Please give him his appellate rights.
Yes, I'll give him his fellas right. Thank you, Your Honor.
You acknowledge your appellate rights?
Hmm.
You acknowledge your appellate rights. If you're unhappy with this, that's how you feel. Merry
You gotta
Christmas, thank you.
acknowledge yes.
Oh, yes, ma'am.
All right.
Yeah. Thank you, that's all for this record, next man.
I need a minute.
Well, I think it's only Luke and Mr. Silverthorne left, so step on up and look at it.
What happened to Palmer?
I don't know where he went.
Evidentiary hearing?
What?
On TV?
It's not Palmer, it's
It's-
Mr. Silverthorne and that's Ida.
Okay,
So
so Mr. Silverthorne, is your hearing going, or is he?
All right, I'm prepared to have a hearing or discuss it with the court.
Okay, then do we have I got it without that, do we have a probation agent?
Yes.
Have you talked about it with the probation agent?
Oh, I have not.
Okay, why don't you guys go
I'll
do
do that
that
now.
while I do this, that's what I'm just trying to get, okay.
Okay, so what are we doing right now?
Snyder.
Hold on. When is that at?
9:30.
Yeah, here it is. This is docket 254504FH, People State of Michigan versus Charles Snyder.
Good afternoon, Your Honor. Natalie Maycomber on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Snyder, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
Have you taken any medication yesterday or today?
Just my blood pressure and cholesterol.
So anything that would affect your ability to understand the court or your attorney?
So anything that
Would affect your ability to understand the court or your attorney? Are you supposed to be on medication you're not on?
No,
Any sign of fever, COVID, or other illness?
no, ma'am.
Sir, you pled guilty to weapons, firearms, discharge in or at a building punishable by 10 years. Do you recall that?
Yes, ma'am.
All right. And on behalf of the people, any corrections, additions, deletions?
No, Your Honor.
On behalf of defendant, corrections, additions, deletions?
No, Your Honor.
And scoring is fine?
Yes, Your Honor.
Yes, Your Honor.
Thank you. On behalf of the people, do we have a victim?
No, Your Honor.
All right. And what would you like me to know?
Thank you, Your Honor. We just asked you to follow the recommendation.
Thank you, counsel.
Thank you, Your Honor. Your Honor, Mr. Snyder has a very limited criminal history. I believe the most severe thing he's ever been convicted of was an OWI a number of years ago. This is a situation where he had been drinking for several hours and his and the son of his long-term girlfriend had been drinking himself for several hours. They got into an argument and Mr. Snyder fired off a gun to scare him, to send a message or something along those lines, not trying to hurt anybody. This is really a once-off type of event when you look at his entire history here. He said he's 63 years old at this point. Your Honor, I would ask the court to sentence him to a term of probation. He's certainly willing to do any classes that the court would ask of him. There haven't been any violations of the no contact order. I would ask the court to consider lifting the no contact order at this time, as, like I said, his long-term girlfriend's kind of in the position of not being able to be in the same room as the two of them at the same time. They do not have a history of violence or anything along those lines. Like I said, this seemed to be kind of a one-off, very poor judgment or while intoxicated type of situation. Yeah.
So, sir, do you have any weapons in your home?
Yes, ma'am.
Guns?
Yes, ma'am. They're not my weapons.
But they're in your home?
Yes, and they're locked up. They confiscated the one that I used.
Do you have a key or access to the key?
No, I do not have a key to it.
Did I give you, or did somebody give you permission to have those weapons in the home regardless of whose they are?
No, ma'am.
Are they your girlfriend's?
Yes, ma'am.
Is she willing to get rid of them? Here's the deal. She either gets rid of the weapons or she gets rid of you. She got to choose.
Okay.
Is she here?
Yes.
Ma'am, please approach. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Please state and spell your name for the record.
I'm Angela Witt, W-I-T-T.
Why do you have the weapons? I mean, and I don't mean this disrespectful. I was in the military for 20 years. I'm not disparaging anybody for having weapons, but they're a great responsibility. And what we have is something that could have been a deadly tragedy. And I don't know if you have weapons because they're from your great grandfather or if you have them for some other reason, but I want to know because I'm concerned.
My husband, my late husband, owned the guns, and I just kept them after he died. The kids, I can give them to my son. He does not live in the house. I have 3 boys. I can get rid of them, but they've never. We used to just go out to the farm and practice, you know, target shooting and stuff. So.
Okay, so how old are your sons?
20. I have a 30-year-old, a 35-year-old that is an alcoholic and makes everybody crazy. And then the one that actually has his CPL would be my son Wesley. He's
So he could take the weapon?
27, yeah, 26.
And is he responsible?
Very. He works for the credit union.
Are you opposed to doing that? I mean, I
No,
understand.
ma'am, I'm not. I totally agree.
Great.
Yeah.
You do that.
Okay, I will.
Great.
Can I just say one thing about the sitch?
Sure.
My son, there's not one person who will tell you he is the most belligerent, unbelievable piece of work when he's drinking, and that's all I want to say.
Ma'am, I respect that you're not an enabler and that you acknowledge that. Hopefully they'll get some help before something happens.
Yeah.
But shooting a gun in the air, what goes up must come down. That has also killed people. I've had those cases. And, you know, like I said, I'm not opposed to the Constitution or the guns. I carry one myself. I can break them down, put them back together, fire them, clean them, do all of that. I get it, but it's such a huge responsibility, and when misused, people die.
Yes,
So we are lucky we're not here on homicide.
we are. I agree with you. And I kept the guns when I lived alone after my husband passed, and then it just kind of, I will give them to Wesley.
Great,
I would
the
be happy
answer
to
is
do
if
that.
your son's acting up and you wanna get him some help, it's called 911.
They'll help them.
I'll help him. You can't be drunk and disorderly. There's lots of things that can happen. And sadly, sometimes it takes an arrest for us.
Last time they came, they left him there.
Well, ma'am, it might be that he needs to go, they need to PRT him and put him incarcerate in the mental health for 3 days. I don't know the circumstances, but
I can always try the phone
keep calling 911, ask for some help. There might be some people in the community, or there is a hotline for community mental health where they will actually come to your house. So I don't know what's gone on, but nobody should live that way. And I appreciate you're not an enabler, but that means availing yourself of the resources, no matter how hard it is, because you want your son to be safe and the community to be safe and you and your family to be safe. So if he needs that kind of help, keep down 911, talk to community mental health and all of that, but I need you to get rid of those guns.
I'll definitely do that.
Great, thank you. Yep. All right, anything else you want me to know, sir?
Like I said, it was a stupid act on my part. Like he was being very belligerent. The language and the way he talked to his mom, I lost my temper.
Okay.
And him being a big guy, I felt I needed protection in case he came at me.
911. 911. You know, the beauty of you have a cell phone? Do you have a cell phone? Is that a yes?
Yes.
So you can ask everybody who knows me. I lose my cell phone constantly. I set it down and then I don't remember where it is because I'm always doing 10 things. So I have Siri and I say, hey Siri, where are you? And see, Siri just said I'm here. Now, I'm gonna say this and Siri's probably gonna do it, but if you're in trouble, do the hey Siri on your phone. And if you're in this argument, you can say, hey Siri, dial. I do it now with hey Siri. I've done that and showing people and it's actually done that. You don't even have to move. Just tell your phone to do it. And magically Siri does that. Don't get a gun. What goes up must come down. And this has happened a dozen times in our community where people, for New Year's or for birthdays or the 4th of July, or because they're angry, they shoot up in the air and someone dies. You are lucky you're not here on homicide. As I said, I don't care how angry you get, we have law enforcement. They are called peacekeeping officers. So you got arrested and you maybe should not have been. You just took the wrong action.
Yes, ma'am.
So I hope you've learned your lesson.
Yes, ma'am.
Sir, you're gonna pay $130 with the $68 state cost. Of the $130 is for crime victims. You're gonna serve, so that's $198. How soon can you pay that?
Next couple months.
Can you pay it by February 14th?
Yes, ma'am.
Great, don't forget me on Valentine's Day, as I said earlier. That's due by Valentine's Day at 4 PM in our courthouse.
Yes,
You're gonna serve 2 days with 2 days credit, and your significant other is going to get rid of those guns.
Yes, ma'am.
You have 42 days to appeal and to request appellate counsel. Now, do you see it in your appellate rights?
Yes, ma'am.
You'll be in my courtroom except as
No, ma'am.
Thank you.
No, ma'am,
That's
I'll
all.
make sure you have your fine paid by the 14th.
Great,
Yeah.
thank you.
Thank
That's
you.
all.
Did you get the
No, done. I get better things to do with resources.
Oh, absolutely.
Thank you, ma'am.
The next. We do Mr. Silverthorne first.
Mr. Silverthorne, will you all approach to see what you're doing?
Right.
Just because I like you.
I think the whole purpose of resetting the time here was to get a report from. Actually, the report was done a bit ago, but we've never sent out somebody. Grandfather. They brought me a copy of the minutes. and sent that to you, and that was right. If I had gotten it sooner. If I had gotten it for it and. She recommended the medication that she taken. Which I think they didn't have any other suggestions.
Mr. Castillo?
Yes. But he's not certain. I just told him not to. Or mental health, or yeah, he program to complete. Tomorrow's tricky ones for TV program is if we got the option that mental option. Yeah.
What about non?
I don't know.
What's going on? How much difference is
We have a total of 280 days. He's high, so we're coming up on that.
How close is this?
Yeah. We're basically trying to get that right on spot.
We done now? Do you want to know some, or do you want to do it?
Okay, go for it. I told him Meredith, so.
Or do you want to do call?
No, so this is what we make it up. Was exactly what we did. We did actually put that out there and walk out to everybody. You want to see those? He's got a long-term diagnosis. He's also going to and then we got to have there's only a couple of big guys. Yeah, put it back to the old. Perfect. Yeah, we're not gonna- First reading. Yeah. April 22nd. Yeah. Almost. Yeah. Well, that was. Whatever you asked for last time we were here. That was its initial discharge from. parents. This is the second. The first issue that cut back. The second issue was. It's not a. Yeah. Just the way that. They give. He has it there all the time. So, he does.
All right, we need, we're going to go into a closed courtroom.
His
Grandfather can stay,
grandfather, he has a sister. And,
whoever his support people are. can stay.
okay, that'll be his sister, his grandfather. His baby mama, one with the 1-month-old, knows that she can take a child out of it. And then he has his best friend.
Okay.
You know, these two agents back there are training.
That's fine. They're part of your office, just fine. So do we have anybody who needs to leave the courtroom?
I have a comment, Mr. Emerson, for a second. Mr. Emerson, you have to, we're having a closed hearing.
Which.
All right, is there anybody in the courtroom not attached to this case?
Baby mama. with
Okay.
Mr.
Counsel on another case?
His child.
You'll
And
be,
the lady
all
behind
right,
him
so you need to
is-
step out
is his
until,
sister.
we'll be calling you
He's
back.
still
in
with
a moment.
probation and training.
Yes. I actually recognize him.
Your Honor, do you want me to?
We're gonna go into a closed Zoom room. We'll be right back with you.
Always.
Right.
Jared, you're good to tell us.
You may be seated, that's fine. Thank you, I snuck in.
Sorry, Josh.
It's quite all right.
You're good to tell
We
us.
just need to make, wait a moment, order.
Oh, okay. Okay.
The silence is deafening.
Just trying to fix something on this computer. He needs to be in a break room. He's gonna.
Yep.
I think I'm in a break room.
Yep. I can't move, you should be able to move yourself out of this.
I can't. Well,
Because I can't, I don't have any way to get you into the main session.
Close the breakout room.
Well, no, because Jared needs in it, so I can't close it.
Can you close it and then reopen?
She should be able to get out of it herself and just hit like, we, like in the bottom right-hand corner where the X is.
Let me see.
Where it says and, it'll say like leave breakout room.
Doesn't put him in, okay, I'm out, but he needs to be in. Mr. Austin, we're getting you in a breakout room.
Okay, thank you.
Yep. I don't see his clock now.
Yeah. All right, looks like it's fixed.
Oh,
Thank
there it
you.
is. I see it now.
This is docket 25-2686CZ, City of Lansing versus JAJ Property LLC. Council, your appearances for the record.
May it please the court, Matt Staples for the city of Lansing.
Good afternoon, Your Honor. F. Joseph Luda appearing on behalf of the city of Lansing. Thank you.
Good afternoon, Your Honor. Edward Zanning on behalf of the defendant JAJ Properties LLC. Also present at council table with the court's permission is our intern Ava Krall, Krall.
Thank you. Would you all like to have a seat? There are some seats up here. There's plenty of seats up here.
Thank you.
Thank you. All right, we are here for our weekly meeting to look at the status, and council and I had a meeting, which was a continuation of last week in regard to a consent agreement. I have received, I didn't count them, 50 letters, maybe more. Most of them said the same thing. Some people wrote me other kinds of notes. I know that you're all concerned. Where are you gonna go? What are you gonna do? Don't disrupt the family. Let's keep going the way we are. I have not followed the law because I see you. We are all one paycheck, many of us. One paycheck away from where you are. Things have gotten out of control financially. Government isn't really seeing people, seeing the desperation, the need for housing, food, shelter, basics. I get that. I have held this open and let everybody stay because I don't want anybody treated like trash. Because I don't want you removed and discarded. Because you are all valuable human beings who have fallen on hard times. And as I said, no one is immune from that. However, I still have to abide by the law. And there is no provision in the law to overtake a citizen's property and simply rest there, especially without permission and in situations that are not safe for everybody. I have asked the community to partner together, which they have done, to help all of you figure out who's there, what your needs are. I have visited, I've watched the news, I've seen the pictures. I know that you are all peaceful, that you work together, sharing food, heat, fireplaces, and all of that. Your needs have been looked at, not just by this court, but by the community partners who have come forward, as well as all council, the mayor, law enforcement, the property owner, and where you reside, as well as other property owners in the area. So I want you to know this decision, I believe, is in the best interest of all of you. Before you get up in arms about it, I implore you to listen to everything. I will allow you to ask some questions. I know a couple people walked out of here already anticipating the worst. There isn't a worst scenario here from what I see, except that if you stay on the property and continue to violate the law, there are worse things that could happen. And I also want you to know, I understand what it's like to be out there in the cold. I served in the military. I've done winter training. It is not my favorite thing to do. I've not been homeless, but I've been out in the woods for days. I've eaten cold food. Starts out warm, by the time it gets to your mouth, oftentimes it's cold. Nothing made me happier after winter training than getting in a warm shower in my own bed. And that's what we want for all of you. I've not lived your life. I had a little taste of it, but I understand and I want you to be safe and in a warm environment with all of your needs met. So with that being stated, on behalf of City of Lansing, Please outline the plan and tell us where we are.
Certainly, Your Honor. The plan is that the city will be providing emergency shelter via hotel, which will be the Causeway Bay. That will be available. I am told it's available as soon as people want to make them or avail themselves of that service. The city will additionally working on providing transportation Monday and Tuesday of next week. Hopefully Monday and Tuesday, but at least one day next week for individuals to go from the encampment to Causeway Bay. That's gonna be, it would be a minimum of 6 weeks, assuming everyone takes advantage of that opportunity. The hotel it will be 2 to a room. It can be more than that. It's just up to the hotel's individual policies on the maximum number of people who can be in the room. It's also my understanding, as we are here today, that up to 2 pets, well-behaved pets, will also be able to be accommodated per room. So that is the plan. That again will be happening next week. The request and the order that the court has signed also, as the judge has stated, outlines that the owner has signed a letter of trespass, and anyone remaining after the 23rd would be considered to be a trespasser at that point. The encampment will be then swept of any remaining inhabitants at a later date, but not announced publicly, but that is imminent. That will then follow with the cleanup of the property by the property owner. If Mr. Zaney wants to discuss that part, or if you would like me to continue.
You can defer to the city, Your Honor.
After the encampment has been cleared, the property owner will take steps to ensure that anyone who has not availed themselves of the hoteling does not return to the property. They will work with the city on that if need be, follow up. Individuals would be trespassed, and once you are trespassed, if you refuse to leave, that is the violation of a lawful order. And although we would hate for it to happen, you would be subject, anyone at that point that is trespassing would be subject to arrest. After that, the property owner will work with a contractor to remove any remaining debris on the property and ultimately fully secure the property against any future incursion. And that's the broad outline. The city will be absorbing all of the costs of the hoteling and all of the costs incurred based on this court's preliminary injunction, that being the porta potties, the sinks, the water, the trash. I believe those are the high points.
Additionally, the mayor's working on housing. There's permanent residents that are being looked at and opportunities. There are agencies that will continue to work with all of you, Advent House, the Health Department, social workers, etc., to make sure that what we're looking at is the eventual, hopefully after these 6 weeks or so, permanent residence, housing, making sure you all have IDs, job opportunities, mental health, medical services, treatment. So your needs are met for the long term. This has been delayed by this court for exactly this reason. The property that you're on is not a long-term solution. The long-term solution is to move you along in a methodical way so that all of your needs are met, and so you are no longer homeless. A lot of you have expressed, we do not want our family divided. So these rooms, you will have 2 to a room if you have children or other relatives. There certainly are exceptions. Additionally, you're not being broken up. You're not being taken to all different places in the city. Your family that you have created on this property, which I'm very well aware of, which I saw when I visited, you all have decided that you're all family. Family isn't who you're born into, it's those people we choose, and you've chosen to be together. You will be together at the Causeway. You'll still have connection. You can still reach out to each other. But in this way, you'll be safe. It is unconstitutional as far as I'm concerned, and inhumane to leave you out in the cold only to, when you have frostbite, take you to Sparrow Hospital or some other hospital, have a finger or toe cut off, only to be put back out in the cold for it to happen repeatedly. We have to stop that cycle. This is a good start. There's a good partnership, and I'm hoping that you will all avail yourself of this so that we become the example of what a city can do to come together and do it for the long term, not the short term stay. But it's going to take your continued cooperation and belief in the system that we are really trying to help. There is a provision in this, although all of the statements in here really are closing the matters, and it does say this is a final order and closes the case. I'm retaining jurisdiction. So if you have a gripe, if there's a problem, if either side has not kept up their agreement, if there's a problem in either side or any of you want to bring it to me, I'm still here. I'm not going away. But at some point, there has to be resolution. It's winter now. It's not getting warmer. I need you to be safe, warm, happy, and together. Everybody worked really hard to make sure you can stay together. Your animals can be with you, and you can bring your belongings. The buses, as I understand it, and council can correct me, is not just to transport you, but all of your belongings. There may be things you have to leave behind, but those things that are important to you, we're going to transport. There's going to be people to help you transport them. You're not losing your things. So I think we've addressed your needs. I'm happy to hear from all of you, but I had my law clerk, Brian Ring, make multiple copies of this order so you can all read it and ask questions. On behalf of defendant, what would you like us to know?
Your Honor, just briefly, I just want to echo the sentiment of the city as far as the imminency of things occurring and swift action taking place to secure the property. But I'd be remiss if I did not, on the record, bring up to the court, your opening statement was, I did not follow the law. But I do have to, I think, provide the court significant accolades in that we may have disputed with defendants and the plaintiff here in this case. We may have a different opinion as to what's the written law, but I do commend the court in the recognition and the courage to not forget the law of humanity. And that's one thing Your Honor had forced the feet of the city to recognize in this process, the property owner to acknowledge and provide as such. I know the court will not abandon that pursuit. I will just reiterate though, we have provided, we have obligations under this court order from the defendant's perspective, the property owner's perspective, that have consequences, real palpable consequences, and he too is a human. So as we work through this, we are assuring the court we're going to do so in accordance with the order, with the concept of, you know, what we've reached here today. I'm anticipating, based on the representations of the city, they're going to work hand in hand with us and those community partners. So as we do go forward in this, we have to express to the court, we understand the effect of your court's order and the obligations set forth therein, and we are obligated to follow that, and we'll do so to and including trespass, to and including follow-up of cleanup and securing the property.
And I do appreciate you saying that, counsel. I will always, as you know, we've known each other for some of us for 20, 30, 40 years now. Anyways, I will always prioritize humans and humanity and morality over black letter law. I think that's what I swore to uphold. You all may not agree with it, but I went way over what I should have or what most judges would do, and was willing to accept the consequences graciously. The attorneys here also wanted the best for all of you as individuals, as humans. So they worked with me on my rather unique approach to the law. And I also want to say, that being said, this property will be cleared at some point, and people will not be returning. There'll be a zero tolerance for malicious destruction of property, whether it is the property that you are on or your property for that matter, as things are being removed. So please take what is important to you. If there's something that you are having trouble removing, please let them know and we'll try to accommodate whatever it is. Again, this is a long-term plan. It's not just a one and done. The mayor has plans for long-term housing. And the city is partnering with a number of agencies and people. The community resources are endless, and people have come forward who we never expected to partner and to help all of you. So I am very hopeful that you keep an open mind and you do avail yourself of the warmth of these beds and showers and food and everything that will be provided, and work together to find employment, to find medication or other help that you need. You each should have a copy or will have a copy of the order. Is there anyone who has a question who would like to address the court? Please stand and tell me your name. And maybe you could come up here to the podium for the ease of the court reporter.
All the way up to the podium.
Please raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Thank you. Put your hand down. Please state and spell your name for the record.
my name is Mike Gorshek, Gorishek. I'm president of the board for the Punks with Lunch organization.
For the what organization?
Punks with Lunch. I'm also affiliated with Rennes Studium High and their homeless union. So we've been helping out at the camp.
And you've done a great job.
Right. Can you go into more specifics on which organizations will be helping the city attorney in implementing this?
Well, there are several, and I suspect more will jump in and join us. Do you have, I know Advent House, I know the health department, and I know there's countless social workers who will be there. Do we have a list?
We don't have an exact list, Your Honor. It'll be coordinated by the HRCS department within the city of Lansing.
And what does HRCS stand for the record?
That would be
Human Relations and Community Services, Your Honor. And this is right in their bailiwick, and they are prepared for this.
Right, so there have been a number of organizations who've been helping at this camp over the duration of its existence. I think I can speak for all of them, and that we'd like to be included in making sure that folks are able to transition as safely and comfortably as they can.
I would appreciate that, because I know you know these people, they trust you, and you have provided outstanding service, so I'm sure the mayor's office would be happy to connect you. Mr. Booth?
We have no objection to that, Your Honor.
And I'm sorry, just to piggyback, I believe Joe McDonald from HRCS is here today, so.
Great.
All right, Joe.
With him, yeah.
Joe, where are you? All right, there you are. There, you two can have a conversation after this. How about that?
Awesome. Thank you very much.
Thank you. Thank you for your help. Anybody else? All right, come on up. Please raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. You don't have to keep bending. We got good equipment here. You got a nice deep voice. Please state and spell your name for the record.
Sure. Harold Garcia, HAROLD
What would you like me to know?
I would kind of hope to understand that at least there is some language within these provisions to specifically, like, bolster Mike's point of focusing more on the grassroots community groups that have been focusing on specifically addressing these issues that are affecting these folks at the camps. I used to be homeless for a long time. I got out of it because of the privileges that I had. I had faced homelessness multiple times. I was very young when that happened. I have a 14-year-old daughter right now. You know, and I built my way up out of this, but only because of the privileges I had allotted to me. And I had been doing homeless advocacy work since I was in high school and had watched government officials target specifically groups that try and assist people. And we need to know for certain that A, the contractors that you are choosing to go with, or the services that already currently exist within the city of Lansing in particular, at least understanding that they're not always meeting those expectations for the folks that are currently in these situations, and making sure that there are provisions so that if there are other grassroots community groups that have been much more actively involved in it, be taken into account as at least seeing precedent to get more preferential treatment, or at least choosing community groups over specifically groups that you may have already had contracts with for over decades. Because this is a systemic problem. It is, like you said, not very hard to wind up almost being homeless. If I wasn't in the union and as a journeyman electrician, I would have been homeless back in 2022. I had to buy a camper because I had a dog and a cat that I had to take care of. I still live very far from my daughter. I am here because of the people that I have built a community with here, and the fact that like this has been going on for months. And the fact that like, I appreciate that you acknowledge the fact that these are human beings that are here, that you acknowledge the fact that like, they have put so much time and hours and months and years and work into being able to at least have somewhere to go. And I understand that during the shuffle of all of these things, it is very easy for people to be pushed off to the wayside. And I feel like there are a lot of entities that exist, even when it comes to social programs such as unemployment, food stamps. These things aren't even properly funded by our own cities, by our own states. And they do have a lot of inadequacies that I know many folks from this encampment, just this one encampment, mind you, there are many people that are homeless in Lansing, and not just Lansing, but across the United States. And our services are not up to snuff, period. And the fact that there are people that do this voluntarily and like actually provide better services than what we see from like people who are actually receiving funding from local government, from taxes, are dropping the ball constantly on individuals who are basically going to be swept into in the incarceration system, because that is also another problem. And we do know that like, even though there may be more civil protections in place than there were back in the days in which we created vagrancy laws, specifically for terrible reasons. Okay, I mean, we can look into why the 13th Amendment exists as it abolishing slavery, but also still in its fine print, allowing it to exist under the incarceration system. We could cover the fact that there are private prisons that make money off of people going to jail. If you have repeat offenses, where do you wind up? You're not going to wind up in jail, you will wind up in prison. And as you keep winding up in the system, it becomes more difficult to find housing, to find jobs. And you are treated because of the fact that you have a criminal record, regardless of whether or not it is a nonviolent offense or for something just literally trying to like, even if it's just an inconsequential drug usage charge, because someone is just trying to escape the problems that they are facing on the street. Like this is why it is extremely important, I feel, to make sure that I know we haven't received the copies yet. I understand that you have them printed so that we can look at them. I would love to be able to see what you have on paper to make sure that like we know for a fact that this isn't going to wind up being like, hey, I did this, I've been sticking to this, but making sure that like we understand as far as basic human rights and how difficult, and as you already mentioned, how easy it is to wind up in that situation, how dire it is to make sure that we are showing favor over community members that are showing up in droves to assist folks that are just like you and me, who have wound up here, whether it's because of some sort of like losing literally a job because your boss got freaking arrested, the owner of the company died. Like There are millions of reasons that don't just have to be, hey, I got hospitalized, or there was a recession, which we are facing very soon. So there are going to be way more people out on the street. We need to make sure that we are putting community members such as these unions, such as the resource centers that exist, these programs that literally community members have put their time and effort into to make this happen. We have tax dollars that can be focused way less on trying to increase police presence and instead trying to address what most of these arrests end up being, which is folks being thrown into jail for what? Sleeping in public. You know how many times I got harassed when I was 18, 19 years old for sleeping in public? I have a warrant in Texas, specifically because of the fact that it is for an unpaid public intoxication charge. When they came for a wellness check, we had a motel. I tried to commit suicide. And they ended up taking me outside, didn't give me a ticket, and instead forced me to the fucking jail, pardon my language, forced me to the hospital. Do you understand? I had no health insurance. I have a child, she's 14, and there's no statute of limitations on that. Do you understand how unfair this system is to treat innocents like that?
I see it all the time. We have 1.2 million mentally ill people imprisoned who should be in a mental facility instead of there. One day, maybe I'll run for the legislature and try to fix those things. I see them every single day, what you're talking about, and I try to look at humanity, not the law, because it is broken. We are in a broken system. I understand it, but perhaps what you can do is partner again with the city, Joe, who's here, but also I think that some of you, hopefully, maybe you, sir, should run for the legislature. Change it from the inside, and all of you should vote for people who understand it's people over dollars. And it's certainly, we could debate this all day, sadly, I don't have all day.
I completely understand.
Also,
Your Honor, I apologize.
This is a way to start. It's, I think, more than any other community has done in the United States. Homelessness, as you said, it's everywhere. But it's a start, and I hope we can make this an example and continue the partnership.
I agree that legislation needs to change, but also when it comes to legislation and laws, especially when it comes to civil rights, labor rights, anything that literally protects the constituents of not just this city, but literally the constituents of this country, the citizens of this country. That was accomplished through means of literally civil unrest, unfortunately, right? Such as striking.
That was accomplished through means of literally what?
Like means of civil disobedience, means of striking, are protected rights that we have as citizens, correct?
Yeah, totally agree with you. And you got everybody's attention by being on that property and staying there and sticking to it. I heard you, we're doing this, we've stood for this. It is not the biggest protest. Thankfully, it's been peacefully and I thank all of you for that. This is just one grain in the sand, but hopefully we can add other grains and fix this problem. I don't have all the answers, and I can't disagree with anything you've said, and I've seen it happen from the bench. I've tried to fix what I can. But this is a start, and I just ask all of you to partner with us for resolution, safety, and homes for all.
And I agree. I just want to make sure that it's on the record, Your Honor, that as long as there is a continued effort to make sure that these systems aren't falling and failing, these folks that are currently in these situations because of the system that was built to have these conditions negatively impact you in a way where I don't understand how most people don't recognize that poverty is expensive. It is extremely expensive. When you have none of those privileges, it is much more expensive. And so just making sure that the system that we are actively working, we are here right now in court and actively working hand in hand with you, but we want to make sure that there are provisions and things in here to make sure that we are holding these folks in the system that you also have agreed and acknowledged are broken in accountability. We want to make sure that we are holding them accountable to make sure that these folks do not wind up just left hanging, as we see in most of these situations in which we do see the city step in and offer assistance. And so I'm just imploring you to make sure that if, as long as there's a means of open communication and a way to hold these entities also accountable, to make sure that these systems are helping out these individuals, that is at least being taken into account. And like specifically, even making sure that we have as much of a buffer to make sure folks are able to at least safely move. I think it is awful to know that folks are going to be kicked out of this unused property. I understand that it belongs to the owner of the property. I understand it. But I'm also fully aware of the history of Lansing, the history of the eminent domain, that they did it through Black.
Wait a minute, you're going too fast. But I'm also fully aware of the history of Lansing, the history of
Eminent domain and what they have done specifically to Black neighborhoods historically, the Black businesses that 496 was built over. And
Sure, I can't fix that history and I understand, but it's still the law is the law in terms of the property. So I have, kept this open as long as I can. It's winter now. I want everybody to be safe and in a warm bed tonight. You can go as early as today to a warm bed. Otherwise, they have buses coming, what is it, Monday and Tuesday? So,
That's the goal, Your Honor.
I'm sorry?
I said that's the goal, Your Honor.
So we at least have a start. If they don't hold to their agreement, I am here.
Enough, I will go ahead and read the documents that have been provided to just make sure that if there are any issues, that is there a way that we can at least go ahead and have some sort of an appeal or any way to at least.
If they violate, it's a final order, but if there's a violation on either side, you can bring it to my attention through council or other means, but I anticipate everyone keeping their word.
All right, appreciate your time. Thank you. Your
Yes,
Honor.
ma'am. Yes, there's one other person. Council?
Thank you, Your Honor. I just want to thank the court. We appreciate consideration and your signing the order today. And it is the intention of the city as well as the property owner to make sure that everybody is treated appropriately, that this plan is put into place, that all our community resources are marshaled and put together to get this thing done. And that's when, if anybody has ideas for resources, line up, because we want to utilize those opportunities. So, thank you.
And if you could just take the message to the mayor from me, I think a task force on homelessness with some of these wise people being part of that might be fruitful.
I'm sure that we will pass that on, as well as our housing ombudsman, Mr. McDonald.
Great, thank you. Is there something? Ma'am, please, and whoever, there's another hand raised, Brian, bring them up.
Kelsey Hector, Kelsey. Kelsey. Yep, K-E-L-S-E-A, Hector, H-E-C-T-O-R. I'm the executive director of House of Lunch.
Please raise your right hand to swear.
Hold on, there's talking back there.
I need everybody to be quiet so we can make a good record.
And you're the director of what?
House of Lunch.
You swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury? What would you like me to know?
I actually just have a question. So, I know that you said minimum of 6 weeks, and when I'm reading this, it says for a period of 6 weeks. And so I just want to, get it exact. What is the time in which the city is providing a hotel stay? And is there a max? At the end of that 6 weeks, is that going to end? Is the plan that you guys said that you are working with folks gonna be implemented then, so that we can kind of future plan? And then my second question is more specifically about the buses, I think.
So my understanding on the 6 weeks is that they had to put a time frame on because there's a budget. Everything boils down to budget, but they have budgeted for X amount of people. And if less people are there, that means you may have another day or another week. It depends. They received a really great rate from the hotel who wants to be partnered with us and help. So it depends. So could it be longer? Sure. And there's going to be people who maybe find stable housing, move out so somebody else can move in. So it's going to be fluid, but they're trying to maximize as much as they can. Have I stated that properly?
Yes, Your Honor, that's correct.
And what was the other?
The other question is about the moving of belongings.
Yes, the moving of belongings will be, there'll be people to help the moving of belongings, and then there'll be a number of bus trips. Some things that are not safe, for example, or maybe won't fit in a hotel room will not be able to be brought. I mean, there were things that I saw where, you know, 3-level homes were sort of created. Those things probably are not going to be able to be brought, but your belongings certainly will be brought, and there are people that are going to help you do that. So if we can only get 10 people on a bus because of all the belongings, then there'll be another bus that comes too. So the idea isn't to deprive anybody of their belongings, but rather to take you with your prized possessions. Does that help?
Yeah, and then I do have one more. What's the number of people that we put into the quote for the hotel stay?
There's a number of, I think it was 50 to 70, but it's going to depend. I mean, we anticipated there were, I think we thought there were about 60 people, then it was 70. The numbers have gone, backward and forward. What we don't want is the whole city of Lansing, homeless area, people from every corner or from Eaton County and Clinton and whatever to show up here and suddenly we have 150 people. So we have a very good handle because thankfully all of you have been working with us on who is who. Because then they've been giving me lists. And so those people have been working, been identified, we know who you are. So hopefully we are providing these rooms to our people. And I'm sad that we can't provide Eaton County and Hillsdale County and everybody else, but we can't. This is for this specific problem. Does that make sense?
Yeah, thank you very much.
Yeah, next.
I will say just briefly on that too, Your Honor. That's also based on 2 people to a room, so if there's 4, like if there's groups of 4 that want to sit, then there's potentially some other things that could, but again, we just had to, we really took the money we had and divided it by rooms and per day, so.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. May you put your hand down. Please state and spell your name for the record.
Willie Hayes,
Slow down, slow. Willie?
Hayes, Hayes.
Thank you, sir. What would you like me to know? Welcome
First of all,
back.
I would just like to say thank you for your wise handling of this case. It's been a trial to say the least. We do appreciate, at least I for myself appreciate you stepping on this side of the bench and boxing with the city attorney and giving AJ probably the
Well, that gives
opportunity
me
to respond.
energy. I'd love to do that.
Right, and we truly do appreciate it because it could have turned out entirely different. But thankfully, you stood up and you fought for us as well as the city too. So we do truly appreciate you for that. And also, to curtail on what Ms. Kelsey just said, if at the end of the 6-week period, everyone at the Causeway Bay pursuant to this consent agreement do not have housing, could there be a stipulation in that consent agreement to extend the period beyond 6 weeks?
So here's the deal. I don't have the purse of the city, but as council just said, there may be room to expand it because if there's 2 or 3 people to a room, that means that's, if there's 3 people to a room, that's 2 rooms that aren't needed, they can go to someone else, which means that the money would be expanded. Right now, they looked at how many people and how much money they had and sort of did the math and we came up with 6 weeks. Could it be longer? Yes. The goal is to move people into stable housing, which should be occurring through these 6 weeks. It shouldn't be a mass exodus on week 6 that everybody goes to stable housing. It's not gonna work like that. It's going to be a slow fluctuation as long as everybody cooperates with the goal of, this isn't my permanent residence, I want permanent residence, I'm going to get a job, I'm gonna make sure I have an ID, I'm going to look at what's available and we continue to work together. The only way this works is if we continue to partner together and stay open and honest and really work diligently instead of haphazardly. Do you understand?
Yes, ma'am, I do.
Okay.
And before conclude, I'd just like to thank the Punks Lunch and Khadijah's group, Ms. Kelsey's group, and also all the local groups that assisted us through this. We truly appreciate you guys for that. You really stood up for us and fought for us, especially you, Khadijah. We love you for what you did. Thank you, young. That's all I have to say.
Thank you.
You're welcome.
All right, anyone else? All right, come on up.
Your next thing on the list.
Raise first.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, under penalty of perjury?
Yes.
You may put your hand down. What would you like me to know? Please state and spell your name first.
My name is Khadijah Erickson, spelled KHADJA, KHADJA, ERICKSON.
Thank you for all your, yes, thank you for all your work. What would you like me to do?
I just had a question. I was looking through the consent agreement, and one thing that came to mind is the limited amount of storage that exists within a hotel room, especially if the intention is for them to be doubled up in a room, which is what it is. My only question would be, you know, they have accumulated a fair amount of things over the years, and while I'm certainly not asking that the city pay to store everything, I don't think it's reasonable, you know, to assume that they're going to be able to capture all of their stuff. And so I'm just wondering if during the creation of this consent agreement, was storage considered to be provided for those residents so they aren't forced to make such hard decisions about what they can keep?
I'll let council, if you could address that. I know we did talk about some of that. There will be some consideration made.
Yeah, I believe, and Joe or anyone, correct me if I'm wrong, I believe it's Advent House has a program where they provide some additional storage, so we'd certainly be happy to coordinate with that as well. You know, I unfortunately, I think there's probably gonna have to be some decisions on larger items just because it's the nature of how it is, but the goal is to certainly be able to provide for any personal effects, clothes, that kind of stuff. You know, I think, you know, when we start talking about larger things, you know, that are out there, that's gonna be tougher to figure out, but I know Advent House has a program where they provide some additional storage. So we will certainly continue working with them, and people can avail themselves of that program. Hopefully that, on top of what they can bring with them, will cover most of the true personal possessions. I think the difficulty is gonna come more from, you know, when we start talking about things the size of bikes or car frames, or, you know, I saw the other day like a big dining room table. That's gonna be the stuff I think is gonna be harder, but hopefully all the personal possessions will be able to make, you know, some accommodation for if it isn't at the hotel through that Advent House program.
And look, the media has been here and the community is aware of this. Everywhere I go, somebody's mentioning, you know, what's going on. And I say, I can't talk about it because it's an ongoing case. But I think that when people learn that there might be a need for storage, there's a lot of people who have barns and other areas that might be available once they know, so they could be temporarily stored. So our community does come together. I've never known Ingham County to not come together on a crisis, and this is one of them. So I'm hoping people will step up and say, I've got some space temporarily you can use.
I just would like to put on the record that the Tenant Resource Center is prepared.
Oh, hold on, I want to put on, sorry.
Yes. The Tenant Resource Center is prepared to provide storage units, including tubs so that people are able to itemize their belongings and label it so that they don't lose track of their stuff. The issue with storing it in a private citizen's property is that it can create a whole host of issues, and they're not subjected to the same standard of responsibility and accountability as an organization such as myself. And so that is something I would like on the record that the TRC will provide to reduce the amount of decisions people make.
Was not aware of that, so I appreciate that, but if worse comes to worse, there are a lot of good citizens who store things. All right, thank you very much. Next. Good afternoon, please raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Absolutely.
Please, you may put your hand down. Please spell your name for the record.
Talon Richard Wooster, TALONRICHARDWOSTER.
Thank you. What would you like me to know, sir?
I'm concerned in the fact that my wife might not be involved in some of this relocation, and the fact that I didn't know we were going to be relocated like this. I lost everything through bed bugs and bad
So why wouldn't she be involved in this? You two wouldn't live in a room
I can't
together?
leave her alone. She has neurological disorder. She
Okay.
needs,
And you mentioned that before, so why couldn't you be in a room with her?
I wouldn't have a problem being in a room with her. I was concerned whether or not we were going to be able to stay together.
You could stay together. If I
You
need to
can't
sign
do
a
that in the
court,
shelters. That's what I'm
this
saying.
isn't the shelter, this is a hotel, and if you need a court order that allows you to stay together, I'm happy to sign that, and I'm sure council will prepare that or my law. So if that's a problem, you let me know, okay?
That's my primary concern, ma'am.
I promise you, you two can stay together. Council, any problem with that?
No, and that brings a point I think I failed to bring up earlier. Obviously Causeway Bay is a functioning hotel, so they are ADA compliant, and while we cannot obviously guarantee the availability of what rooms they have because they have other guests staying there in the normal course of business, they do have handicapped accessible rooms for those who may need it. And hopefully, if we have any people in that situation, we would be able to make that accommodation with the hotel.
Does she need an ADA compliant room, sir?
She's perfectly capable of walking around by herself. She just gets confused.
That's fine. I applaud you for staying with her and taking care of her, and you will be in a room together on my word. Thank you.
Thank you.
Anyone else?
That brings another good point, I'll say for Joe's sake and for our sake, to some extent, if we don't have people together, people are gonna be put together. So to the extent you have people you wanna stay with, or you have groups, make that known so that we can try to, when you're checking into the hotel or whatever, put the people who wanna be together, so then we don't have shuffling in the aftermath, but thank you.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Thank you. Put your hand down. Please state and spell your name for the record.
Thank you, Judge. William Lawrence, WILLIAMLAWRENCE. I'm on the board of the Tenant Resource Center.
Thank you. Thank you for being here. What would you like me to know?
I wanted to say thanks for your efforts to do right by the people in this room.
Hold on, can we stop talking over there?
Yeah, we need everyone to be quiet so we get a good record of this. Thank you.
Can you start over? I'm sorry.
Yeah, I wanted to say thanks for your efforts, Judge, to do right by the people in this room. But looking beyond the immediate issue with this park and to the wider issue, I did want to take issue with one thing you said, which is that the community resources are endless. And as a member of various groups in the room and a board member of one, I mean, I can assure you that they are not endless. They're very much limited. If the goal is adequate housing for everyone who is currently unhoused or underhoused. You said yourself that the system is broken, people are too poor, there's too few jobs, the rent is way too high, and we know that the outcome of all that is going to be additional increasing homelessness in 2026. There's only one way that the trend can go. And city officials have also admitted as much, that all they're able to do is nickel and dime a problem that takes dollars to solve. And so what I wanted to ask is, and it's a serious question to you, but perhaps also to the city, is in the absence of the structural change you're describing, and in the absence of adequate resources, if local municipalities, including Lansing, are unwilling to allow folks to exist on public property, but are also intent on filing violations against property owners who look the other way, which is where this all started, where is this going to go? And are other encampments around the city, whether on private or public property, going to be given the opportunity to negotiate a similar deal so that they're treated with the dignity, which I know, Judge, you believe everybody is owed?
First of all, I do not know what my brother and sister judges would have done in this situation. So how you'll be treated by them, I have no idea. There are some that just go by the law and that's it. They wouldn't give you the time of day, and others may very well do what I did. I don't speak for them. I say we have endless resources only because I have seen our community come together, whether it's searching for Ricky Holland or coming together to provide clothing or shelter for someone who's lost it or what have you. I do know there is not an end of people who need resources, but there is an end to finances. So I am hoping that because the media is involved, and I thank them for being here, that they bring a certain awareness to those people who like to stick their head in the sand and not believe this is happening in the capital of Michigan. So I'm hoping more resources become available, even if it's only a restaurant, instead of throwing away their leftovers that are perfectly good, that they drop them off at the hotel. There are things that can be done that are not being done. What you're posing to me is what happens in the future. I can't help you there. If I ever run for governor or something else, I'm happy to look at the budget, but that's not my job here, right? I do implore you to continue to appear in front of the Senate and the House committee meetings. I regularly go over there and tell them I'm not gonna stop coming over till they put in some bills I want. Go to city council, the mayor, and keep at it, because if we partner together and chip away at these things, it is gonna get better. I agree with you. It's only gonna get worse. I don't know what else to do. I only know that I've held my ground here. I've stood with you, and that's all I can do now. I'm going to continue to watch this and make sure everybody does what they're going to do. And I do know that on both sides, I have very responsible, learned, honest, hardworking counsel who have helped put this together and not throw me off the case. And they had every right to do that, let me tell you. I've stretched the law. So I don't have all the answers you're looking for, but for today, I have this. That's all I can offer. But I appreciate the work that you do, and I know it is unforgivable, hard work, and sometimes you're talking at the wall.
Yeah.
But I do hear you.
If I may ask a question, what would it take legally speaking? And again, this may be for the city as well. Knowing that we're going to end up in this situation again, knowing that even as many people as we help, that many more people are falling into homelessness and more. What is it going to take to reach an accommodation where people can be left alone anywhere at all? Because I think in the absence of being able to house everybody, we can all see the wisdom of there being a place anywhere in the world where people can simply exist.
So my response to you is the federal government, who, I don't know if they ever listen to us, and state and local government, because you cannot do a taking. It's what's happened here is a taking of private citizens' property. The state also has regulations, there's laws. So you have to change the laws or do some kind of emergency shelter situation, which the law does provide for, but not for 3 years. So it's called a safe harbor law, but that's temporary, and there's specific parameters of that. So the best thing to do is to look at the situation, analyze it for the good and for the bad, and go to the legislature and say, more of this is going to happen, please help us. I am happy, you calling me, I'm over there testifying, standing with you. I don't know if they're even watching this. Have you seen a legislator walk in this courtroom to monitor this? Have they made a phone call to me? Have they made a phone call to council to say, what can we do? Hell no.
Yeah.
So let's hold their feet to the fire and say we pay taxes. We are worth something. We're all gonna vote you in or out, depending on what you do. I mean, your vote counts.
Yeah. This will be my final comment. I assure you, Judge, we're working on these structural solutions. I think my comments, and I'll leave it at this, is in the absence of those solutions, because we know it takes time and sometimes you win and sometimes you lose. You started out saying that you broke the law. and I think that is something that I think the city ought to take a page out of your book in cases. There's been a what I would characterize as a malicious compliance with the code of the law as it pertains to trespassing or the code violations. Before there was ever a trespass filed, there was an intervention by the city that was intended to bring heat on the property owners in this case. And I know that we're going to end up in a similar situation again in the future. And so I think people of goodwill, in the absence of a structural solution, need to understand the wisdom of looking the other way. And we all need to understand the wisdom of breaking an unjust law when people's lives are on the line. So I'll leave it at that. Thank you.
Thank you. Anyone else? All right, so we have resources here. Anybody want to go to the hotel now? We can talk about that. There are people here to help you. There are copies of the orders. If we need more, please let us know. If you want to room together, please let them know, because it's important that we count how many hotel rooms we need, and if there's anybody who needs an ADA compliant room, those things. So that's a conversation that you certainly can have after this hearing in this courthouse. And is there anything else or anyone else they should connect with so we can get everybody on the bus Monday, Tuesday, or today?
Not that I'm aware of, Your Honor. I will say it's gonna be kind of like a check-in, just as you would at a normal hotel. So as best you can, try to arrive together, try to say, I've got my person, and have that set up so that when you're doing that check-in, they can assign the right people to the right rooms and stuff like that, so.
I hope you all have a very Merry Christmas in your new homes, which although they'll be temporary, you'll be warm with a shower and you can have a good meal, and that your next year gets better and with housing and all your needs met. If not, I remain here, council remains here, and we are in this together for stability and safety for all. That being said, thank you very much. That is all for the record.
Thank you, Your Honor.
Thank you, Your Honor.
May I approach?
You may. Are you gonna miss someone every week?
No, I am. Well, not the first one that we hung out with, right? Thank you. Yeah, you as well. Yeah, thanks for hanging in there. And, thinking about people, the humanity of the moment, right?
I don't know what else to do. Unseated from the bench.
Yeah, I appreciate it. Yeah. And I know a lot of our first
to make over half the lead.
We're doing who first?
Little John.
Who about Big John? He's a rapper. Yeah, oh, I
I want to do it next because Makeover has to leave.
Only our rapper.
And they should be getting her stage, or she should already be staged.
And what else do we got?
We just have a couple civil things that aren't.
Okay. Okay, what time was that one for?
2.
Thank you.
Yeah. One day you'll get a chair like hers.
I know, right? I don't count on that.
Everybody wants to share.
This is gonna be Little John?
Yeah.
Yeah, sure.
That's all I'm thinking of now.
This is docket.
Wait.
This is docket 25-4497 FH, People of the State of Michigan versus Macquarie, Little John. Council, your appearance for the record.
Good afternoon, Your Honor. Natalie Maycomber on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Littlejohn. Ms. Littlejohn is being brought out now from.
Thank you. I just called this case. I'm standing in for Judge Cole, who is not available today. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth and the penalty of perjury?
Yes.
Thank you. Put your hand down. Ma'am, you. We're on bond conditions arraignment and supposed to report to pretrial services for count one, police officer assaulting, resisting, obstructing, causing injury, which is a felony punishable by 4 years and or $5,000. Count two, aggravated assault, a misdemeanor punishable by 1 year and or $1,000. And I have a bench warrant that was issued by Judge Cole on November 17th, 2025, that says you should be held in contempt because on November 17th, 2025 at 12:05 p.m., pretrial services was informed by JSG monitoring that defendant's GPS tether battery was dead and defendant was in non-monitored status and no longer being safely monitored. Do you understand the allegation against you?
Yes, ma'am.
And is that what you discussed with counsel? Have you discussed that with your attorney?
Yes.
Have you taken any medication yesterday or today?
No.
Is there medication you're supposed to be on that you're not on?
Yes, but I
Does
didn't
it affect
receive-
your ability to understand the court or your attorney?
So focus, sometimes I'm doing the best that I can.
Okay, so do you think you understand what I just
Yes,
said?
I understand.
Okay, and do you have any sign of fever, COVID, or other illness?
Fever a little bit.
A little bit, okay, are you focused enough? You wanna come back another day?
Sure.
You wanna come back another day, or you want to proceed today? Do you think you understand?
Proceed
everything?
today.
Okay. Counsel, are you waiting for the arraignment?
Yes, Your Honor, and if I could just make a brief record regarding, thank you. I have spoken with Ms. Littlejohn. I've had her case since the beginning. I am aware that she does have some mental health diagnoses, that schizophrenia, that she has not been receiving medication in the jail for. However, I've been asking her questions as to who I am, why we're here today, consistently since the district court level. And I believe, at least as to making competency type of determination, I believe she understands, at least on the legal side of things, what's going on. I did run through that again today with her down in lockup as well. So I believe she is oriented to time, date, etc. I just wanted to make the record, though, that I do acknowledge that it sounds like what she's telling me, and I do have outside information that indicates she also has the mental health diagnosis that.
But you believe she's oriented to date, time, and place?
I do believe so.
This.
Yes, for purposes of, in terms of like a legal competency, at this time, I continue to monitor it. Thank you.
And will this be a plea? You wait for the arraignment. Will
Yes.
this be a plea or a hearing?
After speaking to Ms. Littlejohn downstairs, I believe that this is going to be a plea with some explanation in terms of allocation. Thank you.
All right, ma'am, you understand the violation?
Yes, Your Honor.
As to letting your GPS tether die, so the battery was dead, and being in non-monitored status as a result of that, not being monitored on November 17th, 2025 at 12:05 p.m., how do you plead?
I'm guilty.
Did anyone force, threaten, or coerce you to plead?
No, ma'am.
Did anyone promise you anything that caused you to plead?
No.
You understood that you needed to keep plugging in the tether, is that correct?
Yes.
And
I plugged it in like a day before I got arrested, or 2 days before I got arrested. And I don't know, I didn't know it was dead.
okay, well, you have to plug
The
it
light is
in.
not ever on, I don't know.
Okay, well, first of all, you gotta plug it in every day, and if the light's not on, or you think it's broken, you call the agency and they'll get you another one.
Okay.
Understand that? Do you
Okay.
have, where, are you living on Woodstock Drive?
No, I'm living here in Lansing. Right now I'm staying at the Holy Cross and.
Are you homeless?
Yes, I'm staying at the Holy Cross in like a warming center. I'm trying to get into a shelter so they can help me get on my feet a little bit. I had my own place and then I got pregnant and lost
Are
my
you
job.
pregnant now?
I could be pregnant. I didn't take a test yet. I thought I was gonna ask for a test probably today.
So you said you were pregnant, so
I could
you
be
didn't know,
pregnant
you just suspect you are.
a little bit.
Okay.
Have you talked to the doctor? Because some of the medication you're taking might not be something you want to take being pregnant.
No, I haven't took a test yet. I'm just guessing. I feel like I'm pregnant a little bit.
Okay. Ma'am, it's cold out there. Do you want to be released or you want to stay in the jail till we figure out a place for you to live and some, and whether or not you're pregnant?
I have somewhere to go right now.
Where?
Where I was staying.
Where is that?
At the Holy Cross. And
How long can you stay at Holy Cross?
they'll let me stay until like if I don't get in trouble. Like if I get in trouble, I can get kicked out. But I don't usually start anything. I wasn't even trying to end that up in jail.
Are you able to work?
Yes.
When was the last time you worked?
Right now I work online. The last time I physically had a job was at McDonald's. Right before I got pregnant, right before I had my baby. This was about 2 years ago.
So you have a child?
Yes.
Where's that child?
My mom has custody of her.
Can you live with your mom or no?
I haven't asked her, can I live with her?
Why not?
It doesn't seem like she will let me stay with her.
Were your rights terminated to your child?
No, I gave up custody of her. She asked for custody. She wanted custody and then I gave her custody for now and I plan on getting her back.
Okay, I know that's hard, but that was probably the right thing to do. You gotta stabilize yourself, man. On behalf of the people,
Trying to relieve any sort of punishment in the court's discretion.
counsel.
Thank you, Your Honor. One moment. Okay, that makes sense. I just want to double check that. Thank you, Your Honor. Ms. Littlejohn has been in custody. So the 9th, the 10th, my notes, it seems to indicate potentially the 10th is when I received notification of her being back in custody, December 10th, that is. Which means we've got about
8 days.
9 days credit at this point. I'd ask the court to sentence her at this point of time served and allow the opportunity to try to be back out here in the community. I do can appreciate the court's concerns. And I certainly do share those concerns, but I also know that it sounds like Ms. Littlejohn also is not getting medication while she's supposed to be in the jail, and that's a concern as well. So I would ask the court to allow her an opportunity to be back out.
Is there a next court date for her?
Not that I'm aware of. Do you see?
I don't see a next court date, Your Honor. I do see that Ms. Littlejohn was taken into custody on the 9th. But I don't see that there has been any other pretrial scheduled. I'm assuming that's because she was in bench warrant status.
Yes, there was one scheduled and then that got canceled by the bench warrant.
Okay, so there's 9 days jail credit.
Yes, sure.
All right, ma'am, I'm going to reinstate your bond You will report to pretrial services as directed weekly. You will continue on your jail GPS tether. You'll show all prescriptions for medication from a licensed medical physician to pretrial services within 24 hours and take all psychotropic medication as prescribed. Follow all doctor's recommendations, including if you're pregnant, you will see a doctor regarding pregnancy, and then follow all recommendations if you are.
Okay, thank you.
You will maintain your residence at Holy Cross, and all address changes shall be reported to pretrial services, the court and council within 24 hours. So if you move from Holy Cross somewhere else, you tell us within 24 hours. If you go back to Holy Cross, I don't care where you're bouncing around, we need to keep track of you, otherwise I have to keep you in the jail.
Okay, yes, ma'am.
And when is, I'm just gonna set this for, has she had a pretrial on this or what?
Hang, I don't know when you're on this schedule.
It looks like she failed to appear for a pretrial. Was a pretrial ever held?
There was a pretrial that was scheduled on the 10th this month that got canceled by the bench warrant. There was a previous pretrial on September 24th.
And that was she failed to appear.
I don't.
It says bench warrant entry.
Yes. Yes, then, Your Honor, sorry. My computer's very slow at the moment. I will note that there is a pending referral still with the specialty court here, Judge J. Mo as well for her. We are working on getting that taken care of.
All right, I'm gonna fill in a date for a next court date. Would you please ask, we probably need a date in January or February for pending these negotiations for the mental health court. So
I'll go grab it right now.
just grab a date for a pretrial. Is there anything else I need to order? All other orders would remain in effect.
Not on behalf of the people.
Not on behalf of the defense, thank you.
No, actually, I'm sorry. If we could ask Ms. Littlejohn to report to pretrial services within 24 hours. Mr. Feenstra was down here earlier and asked us to have her do that.
Yes. So you gotta make sure you check with pretrial services, you know where that, you know how to get a hold of them.
Call the number, yeah, I can call them.
Okay.
Ma'am, if you do not follow these orders, I assure you, we'll keep track of you in the jail. Jail knows how to deliver babies if you're pregnant, so we're not fooling around here. We can't waste resources picking you up, dropping you back, picking you up, dropping you back. We're done. I'm sure Judge Cole will be done too.
January 14th at 8:30.
So you'll appear January 14, 26 at 8:30.
Okay.
And that's for a pretrial. All right, we're gonna give you a copy of this.
Wait, January 24th?
14th.
Oh, 14th, geez.
Sorry, yeah, January 14, 2026 at 8:30.
Saturday. All right, I will. Pardon me.
You'll not have in your possession or control any illegal drugs, weapons, guns, ammunition, those kinds of things, all right?
Okay, yes, ma'am.
So we're gonna make you a copy of this. Merry Christmas.
Thank you.
Next matter. Thank you.
Thank you.
I'll email all the rest of them to you. Great.
Two civil pretrials.
Do you know where we're doing this?
I mean, we tried to, just do it out here so not to leave, but if you want to go back, go back.
Is that all we have then?
No, we have a motion to compel. And a motion for change, so.
Yes. Oh, shoot.
Fine. Let me get, use it out. Yep.
Sorry. That is my information down.
I'll
This is a copy of the bond. Okay. Thank you. You're welcome. Make sure if you aren't able to call in.
25,201. Or, sorry, we have a surplus funds first.
We have a trial.
1281, 25,1281.
In this building.
Where are the attorneys on the,
Okay. So come up here.
healthcare matter?
All right.
Here, here you go.
Okay.
Hold on, let me give it. Let's do this.
I think so. All right, this is docket 22247 and I, Diana Peltier versus Angela K. Allen, Blue Cross Blue Shield of Michigan. Counsel, your appearances?
Thank you, Your Honor. Paul Dillon, appearing on behalf of the plaintiff, Diana Pelletier.
And Thaddeus Dombrowski, appearing on behalf of the defendant, Angela Allen.
All right, counsel, where are we with this? I know we had postponed trial, I think. There were some negotiations going on. What's going on now?
Your Honor, we had postponed for some exams to be taken. One was taken last Monday, another one is scheduled for this Monday. We are scheduled for trial to begin January 16th, Friday. I guess that's jury selection, and then maybe the trial in earnest on Monday. And then we have exchanged drafts of a final pretrial order, trial witnesses, jury instructions, and a jury verdict form, although they have not been finalized yet.
So we're going to trial and you'll both be ready. On behalf of the defendant, what's going on?
Your Honor, I'd like to address a few things. First, we have rescheduled those examinations per the court's order. You inherited this case from Judge Jamo, so you may not be aware that there were multiple motions to compel medical exams in this case. The plaintiff finally appeared for examinations, I think in June of 2025, but she was completely uncooperative during the examinations. She wouldn't answer any questions. One of the doctors said, I can't even do an exam with this patient. So we requested that this court allow us to reschedule those examinations, and the court gave us that right. We rescheduled 2 of those examinations. And actually, we rescheduled all 3. The problem is that our neuropsych examination, the doctor tells me that the closest available date he can get me to do a neuropsych examination is February 5th of 2026. We have a trial date of January 16th of 2026. So I'm going to ask the court's indulgence to possibly move the trial to like March 1st or something like that, so we can get the examination done and have his deposition scheduled.
Is there any objection to that? Or why is she not cooperative?
Strenuous objections, Your Honor. First of all, I disagree with the characterizations. Second of all, this court's very well aware of this case, in as much as in March, this court issued granted the plaintiff's motion for summary disposition as to liability. The court's been very much involved in this. We've been round and round with respect to these examinations. I have a 77-year-old client who's extremely infirm. I was objecting to further. She went through the IMEs. She couldn't participate in them, and I'm sorry that the examinee or the examiners had issues with her. So this time, the court said, "Mr. Dillon, if you're going to claim these damages, you gotta let your client be examined." Okay, I said fine, but I'm going to go. And so on Monday, I went. There's no lack of cooperation whatsoever. I was a silent observer. Problem here is Mr. Dombrowski had an order from this court for these examinations to take place as far back as August of this past year. And so he sat on that and only scheduled these depositions or these examinations a couple weeks ago. And so it's through his own delay that this examination of the neuropsych by the neuropsych can't be continued.
I would also point out that even in the first round of these examinations, which by the way, I have a picture of my client after Mr. Dombrowski took her deposition. I mean, part of her problem is a PTSD, which I understand, that being an issue. It would make some sense to have her examined by a neuropsych, but he did spend time with her and he did write a report, and he's just going to say she doesn't have it. So, I mean, I think he's got the material that he needs in order to provide his testimony. But again, what we're doing here is we're rewarding the delay of the defense here by not scheduling these matters and dragging this out. I would remind the court that this collision took place. My client was run down by it's a pedestrian versus car. This happened in 2020. And further delay in this case is just unwarranted. I mean, it's been one delay after another, and there's no reasonable basis. I would ask the court to inquire as to when the attempt to reschedule the neuropsych exam was made, so that we can see whether or not the defense has been diligent in this regard. But we're going to show up for the second continued IME on this Monday, the 22nd. If the examination were to take place before the 16th, we would show up January 16th. We'd show up for that. But I really cannot bring myself to have to tell my client that this is being delayed yet again.
Counsel, when was it scheduled?
We contacted the doctors in early November, Your Honor. However, as plaintiff's counsel is aware that a neuropsych evaluation can't be done within 6 months of each other. That's why you have to wait 6 months to have separate neuropsych evaluations. You can't do them one and then 2 months later do it again. There has to be a gap between the two evaluations. Plaintiff's counsel knows as well as I do.
Remind me why you have two of them. Why is there two needed?
Because a neuropsych evaluation is a series of tests that have to be done. There are a number of tests that the plaintiff simply refused to do at the request of her attorney. When they said, will you fill out give us this information, give us a history.
Okay, you gotta slow down. My court reporter's had a bad day and you're going way too fast.
Okay. When the plaintiff showed up for these examinations, she refrained from giving information or doing tests. And when asked why, she said, at the request of my attorney. My attorney told me not to. So that's why we had to go through this whole process of rescheduling the examinations. We have both the PM&R and orthopedic examinations scheduled already, and their depositions scheduled. We can schedule the deposition of the neuropsych physician, and as plaintiff's counsel has already told the court, that is a key part of the plaintiff's case. I have post-traumatic stress disorder as a result of this case.
So when is it scheduled?
His exam is scheduled for February 5th.
And there's no way it can be done earlier?
That's the first date I got from the doctor.
It's not really an answer, though.
Can it be done earlier?
Your Honor, like I called the IME physician's office today and asked, is there any other dates? No, that's the first available date he has for a neuropsych evaluation.
Is there a different doctor or you have to use the same one?
I would rather use the same one doctor if I can, Your Honor, but if you want, I can try and beat the bushes and see if I get somebody else. But again, I don't want to have, as plaintiff's counsel's pointed out, he already did half the exam. I'd rather he complete the exam, have one deposition, one guy.
Not only did he do a substantial amount of the exam. By the way, Your Honor, I just take tremendous exception with the representations that my client didn't cooperate. I can tell you, I was at this particular exam. Mr. Dombrowski was not, and my client was extremely cooperative, and I will make that representation to the court. So the representation that she wasn't.
One at a time, you can't interrupt each other.
93 days. She was cooperative this time.
Yeah.
You ordered it.
The issue, well, they've always been under a court order. The other thing I'd point out is that the 6 month examination issue is a non-issue because the original examination had been within a 6 month period of a prior examination anyway. Your Honor, again, my client is so anxious. I really would like, I mean, she's relatively infirm. I would have asked for the court, I was very close to asking for the court for a protective order to be able to even undergo this examination. There is the defense expert could certainly request the report and the records and the raw data that was performed when she was subjected to a neuropsych previously, and render it, from a document review standpoint, and render his opinion that way, which is done frequently. So I really don't relish the idea of her undergoing a neuropsych exam at all, given the infirmity of my client. Certainly not as a result of the delay. The request for this appointment wasn't made until 3 months after this court ordered that she be subjected to this, and we're simply rewarding that delay by allowing this to take place after the current trial date.
Your Honor, if the plaintiff's counsel wants to waive his PTSD claim, I'm good with that. We don't need this exam. But I don't think they're ready to do that.
Well, how do you're not willing to just review the documents and the prior?
Well, yeah, first of all, Your Honor.
Sir, do you need this for your case or not?
Yes.
Is this essential?
Yes. As long as the plaintiff maintains his PTSD claim, yes.
I still don't understand the delay.
I don't understand the delay either, but nonetheless, here's what we're gonna do. I'm gonna do a couple of options. Sir, as doctors go, just like with judges and lawyers, people cancel appointments. I want you to call the office today, not tomorrow, not after the holidays. I want you to call today as soon as we hang up. I don't care what judge you're seeing next. Tell them I said you got to make a phone call. Call that office and be put on a cancellation list. I suspect the doctor may be able to fit your client in. So I'm going to leave you on the trial date that we have. However, if you cannot get that psych evaluation quicker, we will have, I will move it to March 13th, which will be jury selection, and then the trial will be the following week.
All right. How
no more delays. Your discovery, everything's closed.
Okay.
Yeah.
Excuse me. How am I going to communicate with the court, Your Honor, when I have this conversation? You want me to call your clerk, or what do you want me to do?
I want you to call clerk and opposing counsel, my clerk, Brian Ring, or my judicial assistant, 483-6526, Nicole, 517-483-6526, and tell her the call was made and you're on the waiting list.
All right.
Because the doctor may very well have an opening, and then we don't have to delay trial, and express to his staff how very important it is that she get in.
All right. I will do that.
And if not, then the trial will be, we're gonna keep the trial date as is. And if that doesn't work out, and you'll have to keep everybody informed, not at the last minute, then the next trial date's March 13th. This year, you would be the oldest case on my docket that day. So you would be first.
Your Honor, there's another issue regarding my IME doctors. One of the doctors I had do the examination, and as plaintiff's counsel has pointed out, he wants to be in attendance at the exams. We had a PM&R exam done, requested of the plaintiff by Dr. Justin Ryuta. He, at that time, he said, yeah, I'll let the plaintiff's plaintiff's attorney sit in on the exam. However, since then, Dr. Ryuta has said, no, I've had bad experiences with this. I will not have the plaintiff's attorney sit in. Now, the plaintiff's attorney can take his client to the exam. He can wait out in the waiting room. He just can't sit through the exam.
Okay.
So the exam scheduled for next week.
So is the bad experience because other attorneys decide to interfere in what he's doing? Because this attorney just sits there quietly and observes. I mean, that's what he's done in other cases. That's what he said to me anyway.
I can't tell you what the doctor's experience is, Your Honor. All I know is that we scheduled him originally for an exam. She showed up. Dr. Ryuta actually couldn't do an exam. His report's only a page long, says I can't really do an exam with this patient. She's completely uncooperative. Then we rescheduled it with Dr. Ryuta. He just told us, sorry, I can't, I will not have a plaintiff's attorney sit through my examination. So I would say, fine, the plaintiff's attorney can show up, he can take his client there, he can sit in the waiting room, he just can't sit through the exam.
Well, I have a proposed solution, but I suspect, counsel, your client wants you there as sort of a safety net, right?
Absolutely. And
Okay,
not
here's
just,
the solution. Wait a minute, here's the solution. Draft an order, I will sign it to the doctor saying that you're allowed to be there, but you're not allowed to interfere in any way.
Cannot
So,
comment, cannot.
You're just a fly on the wall. You can observe. You can use then whatever he says, you can use it for a cross exam or whatever, but you know, if she turns to you and says, I want a break, then you guys can take a break outside the presence of the doctor or what have you. But I think that the doctor probably does not want the interference, and you know, some attorneys are pretty aggressive with doctors when they disagree. So I suspect he's experienced that. And so if she wants you there, counsel, it's his exam, let him do the exam and that's
absolutely. It is a hand holding process. I mean, she's 77. She's incredibly infirm. I would want to be there if it was my mother. I'll tell you that.
Yeah, but you know, not just having something assuring the doctor that you're just there to hold her hand and not interfere in whatever he's doing. I think that gives the doctor some assurances. And then if he's not happy with that, let me know. But I think that's really the issue. So we can get around it doing that. I've had clients when I was in practice the same way. They want me there for everything. And sometimes that's a good thing and sometimes it's an annoying thing, but we do what we can do for our clients, right?
And again, Your Honor, you want me to contact your staff at 517-483-6526 and tell you what the doctor's answer is.
Yeah, and you'll tell using counsel, yeah, or you can email us. I don't really care. I want confirmation. Yeah.
Thirdly, Your Honor, as the plaintiff's counsel pointed out, you heard his motion regarding liability, motion for summary disposition around the issue of liability back in March. We filed a motion for reconsideration. I have never heard anything back from the court on that motion for reconsideration.
I will have to check on that. I've not seen that. Did you give a judge's copy?
I believe we sent it to everybody, Your Honor. If you want, I'll send you another copy, Your Honor, but.
I'll have my law clerk look for it. If we don't receive a judge's copy, chances are I don't have it because I don't see that. But certainly I will look at that between now and very, very quickly in the next couple of days.
All right. And
I apologize for that. If that ever happens, if you don't hear from me right away, let me know because and make sure there's judge's copies and sometimes they get stuck filed wrong downstairs or not filed at all. So I'm going to check the filing pile. That's a warning sign to me to go check it. Thank you.
And
Your Honor, I do believe that was addressed in a previous conference that we've had, and the court had indicated that it was not being granted. I think this has already been brought up.
No, I don't remember.
I'll look at it. I honestly have too many cases to remember what I looked at, what I said, and I'll look at that. Anything else you want?
One last thing, Your Honor. The plaintiff counsel submitted his pretrial witness list. It has 22 witnesses on it. Which one is he actually going to be calling? I'd like to know that. I think my pretrial witness list had 3 or 4 lay witnesses and 4 experts.
Well, here's the deal. And counsel, I'm sure you can speak for yourself. I expect you to cut that list down to relevant and not cumulative witnesses, but I suspect until all of the depositions, IMEs, whatever you've got done is done, he won't know how to cut it. So I'll expect you to cut it a month before trial, and if not, we'll all meet and talk about it. How's that?
Sounds fine, Your Honor.
Your Honor, I do have an issue with respect to the date. You said the 13th, I believe, the Friday. So I have a somewhat complicated trial that starts in Oakland County before Judge O'Brien on March 2nd. It's very possible that could go more than 2 weeks.
Great. If it does, let me know, and I'll just keep moving it along my docket. Meanwhile, I'll leave it because I also have some trials where it might be moved, but if I don't get you in, it might be June, and I don't want to do that to your client.
Excellent.
So we're
I appreciate that. Thank you. I just want to make the court sure the court and opposing counsel is aware.
Right.
So I'm just making note that it may need to be moved a few days. So we've got a couple different options. I'm trying to be fluid and work with you. So let's do it that way. Is that all right?
That's fine, Your Honor.
Yes.
Okay, great. That's
Thank
all
you,
for the
Your Honor.
record. Thank you.
Thank you, Your Honor.
Thank you.
Oh, Your Honor, will we have a return date for just another pretrial conference? Or is there a due date? Or is there a due date for our actual pretrial order?
Sure, March 13th, I'm sorry, February 13th.
And that February 13th is what, Your Honor, a return date?
Oh, you know what? I can't,
Go ahead.
that's a Friday. Let's do February 11th at 1 o'clock.
Well,
That would be a return date for continued pretrial and all the issues that we're dealing with.
Your Honor, we presently have a January 16th trial date.
Well, okay, I was anticipating the March one, so that's gonna be if it's the March date. If it's January, then we will have, January 7th at 1 o'clock.
Thank you very much, Your Honor.
Okay, thank you, Your Honor.
All right, so you got alternate dates and we'll just have to keep this fluid and all keep the conversation going. I have a judicial assistant, a court reporter, and a law clerk who all can talk to you when I can't, okay?
Okay, thank you, Your Honor.
Merry Christmas. Thank you.
Merry Christmas.
You
too.
Yeah, I see it in court, so. Here's a excess funds.
Okay, what's the name? We gotta put names on these. Why do they just have numbers?
Or a number, whatever.
That's
Or a
good.
time.
And raise surplus proceeds?
Yeah.
Okay, hold on, let me find it before you.
130, 25, 1281.
All right, this is docket 25-1281 CH. In raise surplus proceeds from mortgage foreclosure of 1311 Chester Road.
Good afternoon, Your Honor. Attorney Sean Locke, P78785, on behalf of petitioner Anita Khan.
Thank you. Sir?
Jeffrey Todd Armstrong, guardian and conservator for Mary L. Barnes.
All right, please raise your right hand. You're not a lawyer.
No, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth?
I
Under
do.
penalty of perjury.
I do.
I used to live at 1825 Chester Road, so I know where that is. I drove by it for 25 years. So what's going on here? We have an overage.
Yes, Your Honor. This is actually the second time we've been in front of you in this matter. Back in May 2025, the court entered an order splitting the surplus proceeds of in excess of $77,000 among four separate interested persons, with each to receive $19,263.97. Disbursements were made by the circuit court clerk to three of those individuals, including my client, Anita Khan, and two siblings, Penelope McConnell and Beth Young. As of the time of this motion, Mary L. Barnes has not claimed her surplus proceeds from the circuit court clerk. That has prompted my client, Anita Khan, to file this motion, asking this court to distribute the share allocated to Mary Barnes in the amount of $19,263.90 to my client, Anita Khan, in satisfaction of the civil judgment that she has in another case in this court. Excuse me, that civil judgment is attached as Exhibit 3 to my petition. In a 2021 case, the judgment was actually entered May 22nd, 2023. Judgment in favor of my client, Anita Khan, against Mary Barnes in the amount of $18,093.76 plus statutory interest. Because Ms. Barnes has not claimed those proceeds, we're asking the court to exercise its equitable jurisdiction or equitable powers to release those funds in partial satisfaction of that money judgment that my client has. I will note that, Ms. Khan attempted to submit a writ of garnishment to the circuit court clerk, garnishing those funds from, and the clerk rejected that filing. I understand it's unusual. So we're either seeking an order releasing those funds to, again, Hanitha Khan in partial satisfaction of that judgment, or in the alternative, compelling the circuit court clerk to accept and process a request and writ for garnishment related to those funds.
Sir,
Yes, ma'am.
anything you need to know?
So, I was just appointed guardian and conservator for Mary Barnes. And through the process, she was required to have an evaluation in regards to her mental health. She has dementia, and during the time of the foreclosure and all the proceedings, we don't know necessarily her state at that time, but since the guardianship and conservatorship have been resolved, we have had her evaluated, and realistically, she's gonna need those funds to live her life.
Well, realistically, she owes this money despite needing to live her life. She owes this debt, so how's she gonna do both?
So I'm not denying that she owes the debt.
Okay.
What I'm most concerned with is that she has $1,400 a month in her Social Security and pension to live on. And fairly soon, she's gonna probably need to go into a home because she has good days and bad days, good hours, bad hours. I am her nephew, Hanitha Khan, my mother. And she doesn't know from time to time who I am. She lives with me in my home in the Groesbeck area. And I'm just concerned that she's gonna need those funds. So that being said, I'm not disputing the amount at all, but I would like to ask the court for some sort of payment arrangement so that she can pay monthly in regards to that.
How's she gonna pay monthly when she lives on such limited income? And isn't it better to just live on what she has now and then pay this? And it's for the full amount, or there's $1,000 or so left in there?
Your Honor, the current judgment balance as of today's date with interest is going to be $20,626. So it would take the entire share that's currently in circuit court escrow, which is $19,263. So there would not be any left over after it is applied to this debt.
Sir, I don't see good cause to give you the funds, and she needs to pay this debt. And I'm sorry for what she's going through, but at some point, Social Security and all of that will, when she's in the nursing home, they basically pare you down to nothing, so that then it kicks in. So it's a sad situation all the way around.
100% is a sad situation. Could you possibly adjourn this matter so I have time to speak with counsel in regard to this? I'm gonna give you just a little bit of backstory. Wendell Phillips, who was listed on this order, she was living with him. She left our home in the middle of the night she left with him. She was using him as counsel, and she was manipulated in this whole case. And I'm just trying to get some sort of equitable resolution for all parties. This whole situation has ripped our family apart.
I'm sure you may have a claim against him. When was this judgment entered?
And the original judgment was entered, Your Honor, May 22nd, 2023.
Okay, so statute of limitations on that on this, it has run, I believe, is that right? On the original, not this, the disbursement, but the 2 years, right? On the money that accrued against her?
On the judgment, Your Honor, no, the judgment would be valid for, I believe, 10 years for collection.
The judge for collection, I'm talking about the underlying case.
Oh, the underlying case pertained to real estate, and in fact, it pertained to Mary Barnes's occupancy of the 1311 Chester Road.
Right, so, but that, all the time frames on appealing that have run,
Oh,
correct?
yes.
That's what I'm talking about.
Yes, correct,
Not
Your
the
Honor.
collections action.
Apologies.
So, but based on this and based on what you find, you may have a claim against him. I don't know. Especially if she was vulnerable at that time. So I don't know. You need to talk to a lawyer, but here's what I'm gonna do. Okay, I am going to give you until, it's actually 21 days, so it'll be on or around January 14th, 28 days, if I counted correctly, to find a lawyer to tell you that this is not an appropriate action or to file something else. If after the 28 days, nothing has been filed, then the plaintiff can get the funds in full. And if not, it'll be set for hearing and I'll see what you have to say about that. I suspect that there's really no undoing this, but you may have a claim against this other individual as you start to tell me that whole story, which really is not part of this, but I'm gonna give you 28 days to look at, to consult with counsel to see the validity of this. I think it's valid. I think it's, they're owed the money. So on the 28th day, once that ends and there's nothing filed, then you can collect the money. How's that?
That's fine, Your Honor. Should I prepare an order to that effect right now or wait until submitting, wait until the 28 days to submit an
No,
order?
prepare an order saying that the money will be transmitted to you, your client, whatever, however you want to word it, basically on the 29th days after the 28 days lapse, so he has time to get counsel.
Understood.
And I've done 28 instead of 21 because there's some holiday days in there and we're losing some time, so count those.
Yes, Your Honor.
Okay, sir, that's the best I can do.
Okay, I appreciate it. And we should just be in contact with your office.
The attorney would contact us, file a motion or work it out with counsel. You all can meet. Let me know if I can be of help, okay?
Okay.
Thank you, Your Honor.
I appreciate you.
And then maybe you can exchange information, so you know, he needs to know where to send the information, so, all right?
Yes, ma'am. Thank you.
Thank you. And it'll be 28 days from entrance of the order, so I suggest you get that to me as quick as you can.
Yes, that is.
Okay, we have a pretrial on docket 24 for.
I'm not ready. Hold on.
Oh, I don't know if we're gonna go on. the record.
Oh, okay, go ahead.
Are we going on the record on docket 24-406 NF, this is the pretrial?
Yes, Your Honor, I don't think it's necessary to go on the record, but if the court would like us to.
No, I don't want you to go on the record. My court reporter's had a hell of a day. Is there something we need to go back in chambers, or do we need, or you want to come on up here? What's going on?
Whatever the court would like, Your Honor.
Doesn't matter to me. We could just talk here.
We can't go in chambers because the weapons court team's in there because
We got other rooms that we can use. What are we doing here?
May I summarize?
Please.
All right, so me and Ms.
Camara.
Are working well together in this case. We went to facilitate in mid-November. She showed up, I showed up, but the entity that didn't show up was the Michigan Catastrophic Claims Association. Surprise, surprise. And so the MCCA was not there, therefore we could not have meaningful negotiations. We've continued to work well together since then. This stayed on the books, so that's why we're here. But we do have a plan to facilitate on January 7th at 11 a.m. with the same facilitator we had, Doug Dempsey. What I'm here to ask the court to do is, I guess, two things. We believe it's practical to move the trial date of February 6th. We are hopeful the case can be resolved. There's no need to add undue pressure around the trial date, because this case is ultimately about a rate dispute regarding this catastrophically brain injured patient of my client. There aren't really fundamental medical disputes in the case. It's a rate dispute case. And in my experience, as well as fellow defense counsel, it's the type of case that can be resolved. So I guess the ask is to move the trial date and to order the MCCA to attend this facilitation on January 7th, so it is productive as can be, and that this case can be resolved.
Okay.
That's about it, Your Honor. Thank you.
All right, we're gonna move it to May 15th at 9 a.m.
All right.
It's likely going to resolve, but if, and prepare an order that they must appear, and if not, there'll be an order to show cause for contempt.
Thank you.
I don't fool
Thank
around when
you.
people don't show up. That's just messing with my docket, and I'm not very nice about that.
Especially when they control the negotiations, unfortunately. So 5/15 is our new date, 9 a.m. for the trial. Is there a pretrial date?
Oh, good question. We'll do the pretrial date, April 22nd at 1.
And I would mention, just for the court and your clerk, our office mailed a motion to adjourn the trial date today.
Okay.
So we've already just resolved that.
Okay, great. All right, no problem. And so you've got your, just keep us apprised, because we expect trials and people don't tell us that, oh, they've settled or that we need it, whatever. Just keep us apprised and we're good. Thank you for your patience today. I know you waited.
Thank you.
Thank you, and thank you for serving our community.
Oh, thank
Thanks.
you.
Yeah.
Just two more, Judge.
Just two more.
Just two?
Jeez.
Yep. And then weapons clerk.
Are these going on record?
Yes, one's a motion to compel, and the other's a motion to change business.
What time?
So we're gonna do 25-201 NO next, the motion to compel.
I'm looking.
Page 9, well, unless it's different, except for 2 o'clock.
201, okay, I have that one.
Sorry. All right, motion to compel. This is, you ready?
Yeah, I hate to say.
This is docket 25201 NO. Noel Cotier as next, friend of Ruth Cotier. I hope I have not slaughtered the name, versus Lowe's Home Centers. Counsel, your appearances.
Good afternoon, Your Honor. Tyler Joseph for the plaintiff.
And good afternoon, Your Honor. Ridley Nimmo, appearing on behalf of defendant Lowe's.
Thank you. And what are we doing here? There's a motion to compel.
Yes, Your Honor. I'll be very brief. I know you've had a long day and I know your court reporter is tired. So just very brief background. This is an incident that occurred in July of 2024. My client was 4 years old at the time, Ruth was yet, and she was struck in the head accidentally at a Lowe's in Lansing, and she had a seizure. It was filed in December. This case is about a year old. A discovery was set in May. We have one stipulated order to compel. Responses were received on October 15th. Not all documents were produced. There was a request to enter a protective order regarding some documents. And on that same day, we requested deposition dates for the individuals listed in defendants' discovery responses. So there's 3 things I'm asking the court for. The depositions of the individuals, Nancy Knight, Robert Levasseur, James Martin, Christopher Woodring, and defendant's corporate representative. And the third thing we would like is the insurance. And myself and my firm have had issues with this in the past. I understand many attorneys don't care about this, but we feel we're entitled to all the insurance coverage in this case. What has been produced is one $3 million policy. I know Lowe's that. And I have spoken with defense counsel before this hearing. He is in agreement in making a request for the tower coverage. He's also, we have an agreement to produce individuals for deposition. And the issue with the protective order, I believe we have an agreement regarding the video surveillance that's to be produced and the policies and procedures that's going to be produced. But I would just like an order from the court setting a timeline. It's been a year. This discovery is 7 months outstanding. I want to get this moving. So if we could have 60 days to produce those individuals for deposition, 21 days for the insurance, and then 21 days as well with an agreeable protective order regarding the video and the policies and procedures stipulated to.
Any of that in dispute?
Well, good morning, Your Honor. Well, I don't know if you had a chance to read my response. I did file a response to this motion, and the response was, what are we doing here? This motion is unnecessary, unwarranted. The first thing the motion raises is defendant said they want a protective order for some stuff. They didn't even provide a protective order. Well, I had 30 days before they even filed this motion, gave them a proposed protective order, and I said, this is basic, straightforward. Let me know if you agree, and I never heard anything back.
Okay.
So, I mean, and by the way, the discovery responses said, as it relates to security video, there's no security video of the actual incident itself because there's no video in that area, but there is secondary video that shows them coming in, them leaving. Okay. And so, in the response to that discovery was, we're more than happy to provide it subject to entry of an appropriate protective order. I provided an appropriate protective order, a basic, straightforward one, and never got a response. So,
okay.
So that's
sounds like we're in agreement. Is there anything you're in disagreement?
Well, and so as long as he's fine with entering the protective order for production of the video and policies and procedures, I'm fine with that. I've already said that. I said that in the discovery.
Great. They're in agreement. 21 days they'll provide, and within those 21 days of protective order, sounds like they've already done it. Was there something wrong with the protective order they presented?
Yes, Your Honor.
Well, then you two work it out, and then if you can't work out whatever language, did you ever talk about it? Then you come to me.
It was just overly broad, Your Honor. It was anything that they designated.
Redraft it, give it to them, and if you both disagree, I'm here.
Understood, Your Honor.
Yeah, that sounds perfectly fine to me, and I've been wanting to have that dialogue for a while. And in the order, would it say providing the information within 21 days of entry of the protective order?
Entry of the order, yeah.
Right, yeah, all right.
And
so
then 60 days, the deposition, any problem with that?
Well, here's the other reason. There's no need for any order. I've never refused to produce anybody. Last I knew, the folks that he's looking to for a deposition are still with us. I knew we had to iron out these details. We just had our scheduling order entered. Our discovery cutoff date is not until like mid-May.
Okay.
So in any event, no orders necessary as it relates to the deposition. I've asked for plaintiff's deposition. I assume he's gonna produce them.
Within 60 days, you're both going to set all your depositions and schedule them. It seems reasonable. This case needs to move forward. And we've got the 21 days for the protective order and the insurance and the video. If you can't agree to the language, I am here. Get me on Zoom, get me on a phone call. I'll squeeze you in. Let's get this moving. We have two counsel who should have talked this out before talking it out with me. Try that next time. Anything else?
That's it, Your Honor.
Well, no, I had a question as it relates to the insurance related information. Just so you know, the initial response was Lowe's is self-insured up to like $1 million. I got a response from him. He said, well, wait a second, is there more insurance? I followed up with the client. I said, hey, here's a deck page that says there's 3 million above that. I suppose, and his comeback now is apparently, well, wait a second, I think there might be something above that. I don't know where this ends.
Where it ends is Lowe's can sign an affidavit as to here's all the insurance we have, here's the policies we have, end of story. Then if he finds something else, then there's contempt. Okay.
So the order, are we going to do a similar order to as it relates to the protective order within 21 days of entry of the protective order? Show the insurance information or whatever?
Absolutely.
Okay.
Let's get this case moving.
Okay. All right. That sounds fair.
Communication, people. That's all for the record.
I agree. Thank you, Your Honor.
This one may say show cause, but I don't know if the defendant was ever written over. I don't know if the plaintiff written the defendant over here, so we'll see the MDOC.
I don't see MDOC on here. Is MDOC on here? Is the state treasurer? Yeah.
Your Honor, is not, and they have been paroled.
Just a minute. So are you are here on behalf of the state treasurer?
Yes, Your Honor.
So was there a writ?
There was not a writ because he was paroled, so he was served at his current address.
Okay, and he's not here? You've not heard from him?
He was here at some point. I saw his name in the list on the participants. He was here at one point in time, Mr. DeBoer was, and he was served on November 8th.
So he was here today?
Yes, I did see his name appear in the list of participants at one point in time.
Okay, I didn't see him, but I had so many people on this afternoon. We've had countless hearings, so let me just call the case. This is State Treasurer versus Kendrick DeBoer, who apparently was in the Michigan Department of Corrections, however, has been released and was properly served. This is docket 255635 CZ. Counsel, your appearance.
Brittany Jones, appearing on behalf of the State Treasurer.
All right, and you wanted, didn't we give you an order to freeze assets?
Yes, Your Honor. So today's hearing was to get an order awarding us 90% of those funds that are currently on hold with unclaimed property.
All right.
With what?
Unclaimed property.
90% of those with unclaimed property. He's not here. Apparently you saw him earlier. I don't have a message saying he had to leave, was sick, whatever. It is now 3:41. This was scheduled for what?
2 o'clock, Your Honor.
2 o'clock. Court has waited sufficient time. Nobody's heard from him. Your motion is granted, and you can put in the order that you're going to send to me that he has whatever, 7 days or 9 days, or I don't know, to object upon entry of the order. But I don't know what argument he would have tonight, because he owes the money. Treasury's getting their money. So.
Yes, Your Honor. I will submit it under the 7-day rule so that he can object.
Do it under 7 days so you can, yeah, so you can object, and then, yeah.
Right.
So
Thank you, Your
I
Honor.
think that's most fair. So, all right. Thank you. That's all
Thank
for the
you.
record. Sorry for your wait today.
This is the last one.
Thank you, Your Honor.
I told you I lied there. In fact, there was an extra one.
No, what on earth is this?
A change venue.
Oh my gosh.
Hold on.
Okay, tell
Hold on,
me
I
next
gotta
door, we're
find
coming
it.
in just a moment.
Okay.
Okay, this is,
Wait,
I'm sorry,
what time
this
is
is
that?
transportation.
Okay, okay, go ahead.
This is docket 254291 ND. Michigan Department of Transportation versus Progressive Preferred Insurance Company, Atlantic Specialty Insurance Company, Nordic Insurance Company of Canada, Intact Insurance Company, MCM Logistics LLC, and AB Auto Transport 2001 Inc. Counsel, your appearance is for the record.
Yes, Your Honor, this is Philip Bladen on behalf of the Michigan Department of Transportation, the Attorney General's Office.
Good afternoon, Your Honor. Paula Obleski, on behalf of defendants Atlantic, Nordic, Intact, and AB Auto.
Thank you. And this is a motion for change of venue on behalf of defendant MCM Logistics LLC.
Which I don't think counsel is
not here.
Still here, or they may have left. I don't know what happened.
Don't see anybody here. So the motions, is there any reason that either one of you know that we should change the venue?
Well, I know that Ms. Opaleski filed a motion for summary disposition, so she probably wants that heard rather than move down to Wayne County. We certainly oppose the motion. I did want to address, because the motion for summary disposition date has not been set. There was no hearing date set. We need to kind of get that worked out.
All right, so my office didn't send you one, or what? I can get you one.
Your Honor, I believe that my assistant was trying to get one, and just to, I guess, add a little bit more context to what Brother Counsel was telling you. This motion was filed on behalf of defendants Intact and Nordic.